Honorable members, the meeting is called to order. Clerk of the committee, may I invite you to usher the nominee to take his seat. In line with the appointment, the next nominee is Justice Sir Dominic Adjei, Justice of the Court of Appeal. Honourable members, standing on AS and the introduction, we don't intend to go over them. So at this juncture, I will call upon the clerk to administer the oath.
I, Dominic, Adjei,
do in the name of the Almighty God swear
do in the name of the Almighty God swear
that the evidence I shall give before this committee
that the evidence I shall give before this committee
touching the matter in issue shall be the truth, the whole truth, and nothing but the truth. So help me God.
So help me God.
Thank you very much. May I use the opportunity on behalf of the committee to welcome Justice Sir Dominic Adjei, Justice of the Court of Appeal. Our members, based on the list of the nominee, he happens to be the second person. Hence, the second person to be vetted. I will proceed to ask the nominee to tell us about his background briefly in 2 minutes.
Thank you, Honorable Chair. My name is Dominic Adjei. I was born on 25th of March 1964. I attended Tetrim RC Primary and Middle School. Then I continued to Achumaman Secondary School, now Ifiakobi. Then I proceeded to Wenchi Methodist Secondary School. Then I went to Legon. I did law. Then I went to law school. I completed in 1993. I practiced as a lawyer. I set up the Holy Trinity Chambers in Kumasi. And Ashanti Region Bar, I became the vice president and the president of the Ashanti Region Bar. Then after that, I joined the bench in 7th of July 2010 with my colleague Justice Senyon. We joined the same day at the Court of Appeal level. And the Court of Appeal, after assumption of office, 6 months, I was made the director of the Public Complaint Unit of the Judicial Service. Then I proceeded. Later on, I became the head of the Judicial Training School, JTI, where I served for 5 years, and I was recalled to come and do another 2 years. Then I've served on several committees, including the appeal records. I've been the chairman. Then I've been a supervising judge, oversight judge for almost all the. Then in addition to that, I proceeded to hold several positions, such as Dean, Faculty of Law, Gimpa, as an additional duty. They requested the Chief Justice to nominate me to assist. It was additional duty. Then I did it. Then international levels, I have, before I moved to international levels, I'm a fellow of the Ghana Academy of Arts and Sciences. I'm also the fellow for the Inns of Court Fellowship for 2022-23 academic year. Then at the international level, I've been the chairperson for the African Judicial Network on environmental law. I was the first person to be elected president when we met in Mozambique. Then I've also been one of the 9 members at becoming International Criminal Court judges. And my term expired 6th of December, just last year. Then I'm one of the 11 members of the African Court on Human and People's Rights. And I am in my 3rd year. I was there and I came just last Saturday because of this vetting. In addition, in terms of education, diploma in criminology, postgraduate certificate, then I did Master of Laws in Criminology and Criminal Justice. Then I went to Duke, where I did MJS, Master of Judicial Studies, where I specialized in interpretation of law, judicial education, and judicial management. And I have taught at the law school for 15 years. In 2016, UCC, University of Cape Coast, appointed me as an adjunct associate professor. In 2022, appointed me as a full adjunct professor. Kwame Nkrumah University appointed me as associate professor part-time in 2016, and I've been teaching in that capacity up to date. So, Mr. President, Chair, you said...
Brief in 2 minutes, but looking at your 18 pages CV, I wonder how you could do that in 2 minutes. So I've decided to give you a bit of time. Thank you very much. Honourable members, we will then proceed to conduct the vetting. I will start by giving the floor to subject matter committee members. So, Honorable John Darko, you have the floor.
Yeah, thank you very much, Mr. Chairman.
The rule still apply.
Thank you very much, Mr. Chairman.
One questions.
My Lord, congratulations. My Lord, I've read a lot of your judgments. My Lord, the case is Etilesi Company Limited and another versus Attorney General. This is a decision of the Court of Appeal dated May 2023. My Lord, you delivered a unanimous decision and denied an appeal from the High Court by the appellants, whose application to the High Court for yes, Court of Appeal, yes. So you refused the appeal from the High Court by the appellants, whose application to the High Court for extension of time to invoke the fundamental human rights jurisdiction conferred on the High Court. That decision had been dismissed, the application had been dismissed, and when it came before you, you refused it. Now, as a member of the African Court on Human and People's Rights, don't you think that the interpretation you placed on Article 33, and so my question is, my Lord, as a member of the African Court on Human and People's Rights, don't you think that the interpretation you placed on Article 33 and Order 67 of CI 47,
my learned friend, is it the interpretation the court placed or he personally placed?
It's the court, of course.
Very well.
But I mean, he read the unanimous decision, yes. You know.
That is the court's decision.
Yes.
To ask your question.
I know my Lord is capable of answering this question, So I'm just wondering, don't you think that that decision rather will make it difficult for the vulnerable in the society to they have difficult to access the courts, especially if you look at the fact that some people may get to know about the violation of
Honorable member,
fundamental
you have
human
asked
rights,
your question. Let me ask
under
the nominee
67.
to answer the question. Please. My
Honorable
Lord, your answer.
Honorable Chair, human rights, we talk about human rights, it is time-bound. If you have a look at Article 33(1) of the Constitution, it says that it must be a right that is related to him, and it is being, has been, or likely to be. And rules of courts under Order 67 has construed, has occurred to mean 6 months. And it does not mean that if you do not invoke the court's jurisdiction within 6 months, there is nothing you can do. It is human, and therefore you go and issue a writ instead of taking benefit of human rights application, which is held expeditiously. That is what it means. It does not prevent people from accessing the court, but they must respect time. Thank you, Chair.
Yes, any follow-up question on this?
Yes, Mr. Chairman. I know my Lord serves on the Court of Human and People's Rights, and my Lord rightly stated that you came last weekend. Your term will expire in 2028. If you can explain to this committee how you juggle your position as a member of the African Court for Human and People's Rights and our Supreme Court, I think it will be very helpful.
Yes, my Lord, the question is overruled. This cannot be a follow-up question. I will then proceed to give the floor to Honorable Tampoli.
Thank you, Mr. Chairman. Good afternoon, Honorable Justice Dennis Adjei. I would want us to continue on an exercise that started with your brother, Justice Senor Jamefe. It was inconclusive. It had to do with the scope and effect of various clauses under Article 60. That has to do with the succession architecture, so that in the absence of the president, the vice president shall act, and in the absence of the vice president, the speaker. Now, what if we have all three of them absent from the jurisdiction around the same time? Various schools of thoughts, have expressed different opinions. I have seen that you have a book titled Approaches to Interpretation, Purposivism, Living Constitutionalism, and Intentionalism in Ghana. Major setback in constitutional interpretation as a matter of public law and rights in Ghana, published by LexisNexis. I want to tap into your rich experience in terms of the application of the purposive application to this particular provision of the Constitution. Do you think there's a lacuna?
Thank you, Chair. In addition to what you have said, that article, I have 7 other books. Most of them have discussed these things. Yes, when we talk about the absence of the president, there is something in interpretation which we call capping legitimacy, meaning that whenever you are interpreting or wherever you are providing events, it should end somewhere. So here, if you look at the intention of the lawmaker or the purpose of the law, at any point in time, one of the three must be in Ghana. You cannot extend it to the Chief Justice because the law does not say so. If you go to Article 57, precedence, where the law wanted to say so, the law said that precedence, in the absence of the president, it is the vice president and speaker and Chief Justice. That one is about precedence in the absence of this. But when it comes to, in the absence of president, vice president, speaker, in terms of governance, it is not the duty of Chief Justice. It was Professor Kruje who, in who in the case of Asare as Attorney General, 2003, 2004, expressed a decision which was not ratio in the matter. It wasn't the ratio in the matter, in which he stated that to him, in the absence of the Speaker, it should be the Chief Justice. It was a personal, it cannot be a ratio. Because if you read it, it is an obiter, and obiter does not bind any court. Because that was not the issue before the court. So my simple understanding is that it is to give legitimacy and to end the cap. So the cap has been fixed, the three. Because why do you go? So in that sense, you also go to say that in the absence of the Chief Justice, then in the absence of that person, in the absence of that person, then what is the essence of providing for leadership in your country? That is the essence. Thank you.
Thank you very much.
Thank you. Thank you.
Any
there's
follow-up?
That's right. Mr. Speaker, so by your interpretation, what if by necessity, and there is a Latin maxim that says that necessity, the Vice President has been taken ill, and then the Speaker obviously had to be out of the jurisdiction. There can't be a vacuum. Somebody necessarily has to step in.
I will allow the supplementary question subject to the aspect that says the Vice President is ill, because the Constitution used the expression absent from the jurisdiction.
You know, there have been two Supreme Court decisions on what do we mean by absence of the President, Vice President, or the Speaker. And it is the contrary to purposive interpretation. Because we must look at the purpose for which the law was made. And why do we talk about peace and development? The things that we had 20, 30 years ago, they are not the same as now. So I believe if in future that there should be a decision, the time and the circumstances may change the decision that the Supreme Court may render. It is possible. And we are saying that the Constitution is a living organism capable of growth. And the Constitution can grow at any time, and the meaning can change depending on time, circumstances, and development. Thank you.
I will then give the floor to Honorable
Last follow-up. Last follow-up.
Bafo.
Mr. Chairman, aren't you enjoying the discourse?
You have exhausted your limit. The majority leader wants a follow-up.
Yeah, but Justice Dennis, if you look at the provisions of Article 60, they clearly anticipate, and I do agree with you, that if the President is not there, the Vice President. The Vice President is not there, the Speaker. If all of them are not there, the Vice President and the President are not there for a given period, the assumption is that, let's say, if they are not there and will not come back, if they will not come back, then there must be an election in 3 months, and a new president will have to take over. So clearly the Constitution president, and for what duration they can act as president. So what could have necessitated an obiter to the effect that Chief Justice can act as a president? What, on the basis of which provisions did that come up?
Thank you. It was by Professor Kruje in the case of Suurbaareh. You are interpreting, you must interpret within the context, and you must be fair. You must be fair to the text. Faithfulness, that is cardinal principle in interpretation, faithfulness to the text. Where it has not been stated anywhere, but I do not blame him because he was discussing the position of the law between 1957 and 1960, where in the absence of the Governor General, all the bills were signed into law by the Chief Justice. That was the position then. So he used that one because that regime, the order in council 1957, is different from 1992 Constitution. So at no point in time can you compare the two. So if you look at it, he was influenced by that position. But within the context of the Constitution, it cannot be so. Thank you.
Is it desirable in the context of separation of powers to ever place the head of the judiciary as the head of the executive?
No, please, because we had one in 1957 which brought about problems. Whenever there was a bad law, like PDA, deportation order, the Governor General, Lord Listowel, will travel to England, and the Chief Justice was signed to make him unpopular. So it is not advisable to use the Chief Justice as one of the to exercise one of the executive powers. It is not advisable. Thank you.
Because within the context of separation of powers, if the person who is the arbiter becomes the actor, how do we resolve misconduct by that person or wrongful conduct by that person that gets contested in your court?
Thank you. Thank you, Honorable. It could be a bad practice, because why do you involve a judge or Chief Justice whose role is resolution of disputes, which is different from the role of the executive? If it extends to Parliament, there's nothing wrong, because they are politicians. They were voted for. They put up their campaign, and at the end of the day, they were voted for. So they can act. But where the Chief Justice, you are supposed to be independent, impartial, and you are to go and perform executive function, it will violate every principle of rule of law. Thank you.
Now, looking at, I think you believe in the purposive approach to constitutional interpretation.
I have several publications on it. Thank you.
So you endorse purposive interpretation?
But leader,
of constitutional
do I take
interpretation?
it that you are now having your turn?
Yes, I'm having my turn.
Very well.
You endorse the purposive approach to constitutional interpretation?
That is so.
Now, Article 60 talks about two scenarios: absence from the country and inability to perform your functions. From a purposive approach to interpretation, in this era where absence from the country is not the same as inability to perform your functions, in view of developments in telecommunications and etc., where you can even sit abroad and then chair a cabinet meeting, where you can sit abroad and receive briefings. In fact, on your aircraft, you can actually chair a cabinet meeting taking place in the Flagstaff House. So on a purposive interpretation to our Constitution, given that the Constitution is anticipating absence from Ghana based on an assumption in 1992 that when you are physically absent, you will not be able to exercise your function as president, or where you are actually here but you are unable to perform, maybe due to ill health or some other consideration. Given that that is not really something that practically exists now, can we say that at any moment a president is absent from Ghana and as a result unable to perform his functions, by which reason,
Thank you, Chair. When we talk about unable to perform his function, and it is outside or he's outside the jurisdiction. And if you look at the decisions rendered by the Supreme Court, the one against Honorable Adjei, the law was made because we were scared of soldiers, that the least the soldiers will come. And therefore, as a commander-in-chief, if you are not there, somebody should take over from you. And as I said, when we take into account purposive interpretation, what we do is that we look at the law. We look at having looked at the law, then the next thing that we do is we look at the context within which it was made, context. So having taken it out of the context, then we move to the second stage. We look at the purpose, the subject matter, the scope, and to some extent the background. What informed that? The background, does it still prevail? So I believe if there is a new application, nothing will prevent the Supreme Court may take preventive, because if it is to be construed purposively, then whether the president is in Ghana or not, provided he's not sick, he he's not sick, he's not seriously sick and can perform his function, I don't think this should be a critical issue. Thank you, Honorable.
And can you reconcile a situation where the president is attending the United Nations General Assembly on behalf of Ghana in his capacity as president? He's there. In his absence, the vice president is sworn in as the acting president. At that time, do we have two presidents? The vice president is acting as the president. Yes. So the point I'm making is, do we have one president acting outside Ghana and another president acting in Ghana?
Thank you, Honorable Chair. Honorable Chair, that is why from the beginning I said that there is an issue with that decision, but it is binding on everybody, such as this one. It can change at any time. That is why we say that it is a living organism capable of growth. And in the case of Zenita Lawrence, Justice Tuguba openly stated that because of modern purposive approach or purposive approach, meanings can change at any time. And therefore, if you go for even interpretation and you think that the meaning has changed as a result of time, circumstances, and the purpose, you can still go back to the same court. So I am of the considered opinion that now that we have modernization, technology, and those things, that position, in future, if the opportunity avails itself, it should be changed. Thank you, Chair.
That will not amount to rewriting the Constitution, will it? Because the language of Article 60 is quite clear. The circumstances have changed. That renders its application funny, if I may put it that way. But the language hasn't changed, and the language is not open to different interpretations and fidelity to the language of the Constitution. Will you keep changing the language of the Constitution because circumstances have changed that make its application quite, uncomfortable?
Thank you, Chair. Yes, that is why now in most countries those use constitution. They are talking about either living constitutionalism or purposive interpretation. Whichever you look at it from, if it is a living organism, if at the beginning it was at the ground level and circumstances are changing, the constitution will grow. And that one, it will not materially affect the substance. It is the meaning that you are going to attach to it. And either you use purposive approach to interpretation or the living organism, which the Constitution is supposed to grow, which Ghana has embraced into 4 and Attorney General. It has been celebrated that the Constitution in Ghana will grow. Otherwise, if you talk about pedantism, then we are going to talk about literalism. The Constitution will never grow, and it will cease to be a constitution. It will be treated like any other document, such as Ordinary Act of Parliament or CI or LI. But the Constitution is different. That is why we say it is sui generis. It is unique, and because it is unique, its interpretation may change depending on the circumstances, but it will not affect the substance of the law. And what I would also like to say is that when we are talking about living constitutionalism or purposive interpretation, what we seek to do is that the Constitution must be able to address normal and or abnormal circumstances through proper interpretation. Thank you.
I'm being guarded by my chairman. He says that I've asked enough questions.
No, it's far from that. I will then proceed to give the floor to Honorable Ewa.
Congratulations, my Lord. My Lord, can you please, by way of clarification or information, let us know whether it's a partnership or a limited liability company or a company unlimited by shares?
Thank you, Chair. Chair, in Ghana, you can register a company, a law firm, as either sole proprietorship, unlimited liability, or
What you want, but it is the answer that the nominee wants to provide.
It was registered as sole proprietorship, and it was as a limited liability is that once you own a firm, your liability is unlimited. Because if you dupe somebody, you use fraudulent means to take money from your client, and you say that it is limited to my shares. No, it is limited to your own properties. That is why no country allows a company to be, a law firm to be registered as a limited liability. It can be unlimited partnership or sole proprietorship. So Holy Trinity was sole proprietorship.
Now to my substantive question. I wanted information.
You don't have a preliminary question and a substantive question, so you can either ask a follow-up.
Mr. Chair, very respectfully, the basis for my question was the reason why I sought clarification.
Honorable member, you are entitled to one question. You have asked the one question. So if you don't have a follow-up, let me give the floor to another person.
What do you make of a lawyer who maintains an interest in a firm after he has joined the bench? What do you make of it? Is it appropriate?
Honorable member, this cannot be a follow-up question. The question is accordingly overruled. I will then proceed to give the floor to Honorable Akurugu.
Thank you, Mr. Chair. Congratulations, my lord. Yes, your students you've taught before speak highly of you, your human relation, and your command over the law. And you make law so easy. And I think based on that, I had an encounter with you, and I was contemplating going to read law. But there is this issue concerning about expanding access by breaking the monopoly of Ghana School of Law in the training of lawyers. With regards to Makola, you go to do your LLB, then Makola. So, thank you.
Thank you very much. Yes, my lord.
Thank you very much.
Your answer.
The legal education in Ghana is confronted with multiples of... We had emerging universities. So the students were not getting admissions. Then it was decided that we should have 2 campuses. Then we have... Even though last year, the law school tried to admit about 1,400 students. But how many students are turned out from the universities every year? We used to have only 3, 4, 5 universities, and now we have about 13, including those who do theirs outside the country. So at the end of the day, if you look at those who sit for the entrance exam, you may get about 3,000, 4,000, and the school can take only about maximum 1,400 students. So here, there could be a policy decision. The policy decision that I read online was that why don't we allow some of the schools to do the bar, and we use the law school as we use the law school as examination center, accreditation, monitoring, and evaluation, and other departments to ensure that the integrity of legal education is not compromised. So we can have it. We can have, because it is a policy decision, and as a judge, I don't want to delve into policies. But what I would say is that if the most important thing is that if feasible studies have been done and it has revealed that this one is better than what we have now, there is nothing wrong. I will only have an issue with it where there is no feasible studies, where there's no feasibility studies, and we are just jumping the gun. But where we are satisfied that we have examined this, and this is the better option, we should go for it. Thank you.
Thank you. I will then proceed to give the floor to Honorable Anthony Imie.
Thank you, Mr. Chairman. Congratulations, nominee, on your elevation. You're almost there, if you pass the test. Now, let's look at AI, artificial intelligence. With the emergence of artificial intelligence, would you support the criminalization of misinformation, disinformation, and the posting of...
If you do it ordinarily, it is an offense. And therefore, if you transpose it...
Now, don't you see such a legislation as...
Ghana, we have the Communication Act. The Communication Act has criminalized some acts. Because, for example, if you want to expose the nudeness of somebody, you are saying something that is prejudicial to the security of the state, and you do it on social media. If you do it in the country physically, it is an offense, and therefore, if you do it on social media and it is an offense, it is not an extension of anything. Assuming it is not an offense if it is done within the jurisdiction, and you do it on social media, and we are criminalizing it, that one, it will be wrong. But if you do it in Ghana, physically, it is an offense. So wherever you do it, it should be an offense.
Any further question?
Thank you very much. My next question. My Lord, recent surveys, etc., suggest a decline in public confidence in the judiciary. What specific reforms would you propose to restore trust in the judiciary?
Thank you, Chair.
Yes, Honorable Nominee.
Chair, when I was the director, that we give either to the judiciary, the judicial officers or staff. The reason is that when we are talking about corruption, we are talking about something which is bad, then we must make it a conscious effort to fight it. If you do not fight it, it will become endemic. And therefore, the most important thing is that we need to first and foremost conscientize ourselves about the effect of corruption. Then the second one, one thing that people of Ghana that you don't do is that if a public officer either it, then when it comes to assessment, you say that you will not mention the name, then say that the whole judiciary is corrupt. That is the problem, and it is about perception. And I can talk about personal experience as a director of the Judicial Training School. On one occasion, I was training, then somebody came to me to complain about somebody who was taking money from him. We made the inquiries. I was then the director of the Public Complaints Unit of the Judicial Service. We investigated the person who alleged the money to the judge and was coming to bow to show that the person who is accompanying him is the person who gave out the money to him. But it was false. So these are some of the things that we do and we must stop. In most cases, if you listen to some of the TV discussions, social media, you know, instead of bolstering the faith of people in the judiciary, we are rather saying that the judiciary is corrupt. But if you ask for evidence, we must be bold. If you have physical evidence, we must use to substantiate. Otherwise, we shall be talking about perception, because any person who goes to court is bad. So apart from training, we need to conscientize ourselves. Then the third antidote is that if a public officer corrupts himself, that person must be prosecuted. Thank you.
Now, my last question. In your view, how should the Ghana legal system evolve to address matters like climate change, environmental degradation, resource extraction? Let's take into consideration the current issues related to Galamsey, which has been ongoing for some time now. How should our system evolve to nip all these menaces in the bud?
Thank you, Honorable Chair. Honorable Chair, we talk about judiciary, and the judiciary, we are moving from the traditional judiciary to the modern judiciary. Now, Judicial Training Institute, we teach environmental law for judges to equip their capacities. Unfortunately, most of them do environmental law at the faculty. Law school is not done. But when they come to the judiciary, the initial training, it has been incorporated, the induction, as part of the system. Then in addition to that, we have continuous judicial education. And these are the things that we introduce to the judges. And was it 4 years ago, there was a case in Takwa where the judges was accused that the judge, somebody was involved in illegal mining. It was brought before the judge. The judge sentenced the person to 6 months. I called for the docket on behalf of the Chief Justice. I was then the director of the Judicial Training School. When it came, the police did not prefer minor offense. They prefer, the charge was trespass. So, if you haven't seen it, you may believe that the person has committed offense under the Mineral and Mining Act and the minimum sentence ranges from 5. Meanwhile, the police who arrested that person preferred the charge of trespass. So we need to build the capacity of the judges. And when I was the chairman for the African Judicial Network on environmental law, I made sure that the selected countries, the pilot countries, Ghana was one of them. So they gave Ghana, is it about $60,000 or so, Judiciary, to have a manual to train on environmental law. And I made sure that the contract was awarded to a Ghanaian. He was Mr. Asumda. He used to be the dean of Zenith. I don't know whether he's there or not. And he prepared it, we validated it, and it became the property of the Judicial Service. So these are the things that we need, because environmental degradation, air pollution, sea pollution, illegal mining, if you do not fight, it will fight us. So what I will conclude is that, yes, we need to build the capacities of the judges as well as lawyers, so that when we get cases involving those matters, we will not fall short. We will do justice to what the law says. Thank you, Mr. Chair.
Now my last follow-up question. How would you balance swift environmental protection through deportation against due process rights in criminal law?
Honorable Chair, I will use my position as the chairperson of the African Judicial Network on environmental law. We use the two together. It is a tool that you need the two. You must take drastic decisions in environmental law, at the same time pursue criminal charges against them. Because if you do one to the advantage of the other, that means those who are not within the net, they will not be caught. So ideally, we need the two to fight. It is not an alternate, it is joint. Thank you.
Thank you very much. I'll proceed to give the floor to Honorable Adjei Omar. Honorable, you have the floor.
Thank you, Chairman. Sir Dennis, congratulations, my Lord. I want us to talk about this House, Parliament. Of late, we've been having some challenges about the privileges and immunities. And I would like you to tell this committee how best, or what are the privileges and immunities, and how best can we safeguard it. Thank you.
Thank you. Parliament is likely to lose its existence if it loses its privileges and immunities. The privileges are the additional rights that are given to members of Parliament to enable them to function. That is, they must be bold and they must hold government accountable. But if the privilege is not given, or the immunity, they are not immune from acts such as being arrested. You have said that at Parliament, you have said something, then you are hunted for. That ordinarily would have constituted crime, but you are immune, crime or civil wrong, but you are immune from that one. Honorable Chair, let me give you an example. In 1215 AD, when the Magna Carta was signed by the dames, the barons, on the other hand, and John the King, it was 1215 AD, meaning we are ending rule by law, we are moving to rule of law. Now, when they moved, and Parliament insisted that they needed immunity, the monarch said, we will not give you immunity, otherwise we'll be at par. And they fought for 474 years until 1644, when the the English Civil War. The English Civil War was brought about the rift between Parliament and the monarch. Monarch was eroding Parliament of its privileges and immunities. That was why they fought. And fortunately, Parliament was able to overpower the monarch and overthrow monarch. That was where Cromwell became the president. They changed from monarchy to republican. And when Cromwell died, his son, Richard, took over. Richard was also messing up. Then they went back that we should go back to the monarchy. And the monarchy, they brought in James II. What happened? When James assumed power, James said, Parliament will not allow you to exercise freedom of expression. Closed book doctrine will not allow you. We shall interfere. You know, it brought about another war. And that war, James ran away. And that brought about the first time that we had a male and female monarch coming together. That is Mary II and William III. When they came together, then they were forced to sign the 1879. And when it was signed, that was where it said that Parliament, you have immunity. You can have closed book. When you have matters before you, the court cannot come in. The court will come in after you have decided and the outcome offends any law. Then when you go to Parliament, you have absolute privilege in terms of what you discuss and what you say and what you debate. Unless you are stopped by the speaker and you fail, then that one, the speaker may deprive you of your immunity. Then they said that if you are talking about Parliament, it should not be limited to only Parliament House. So now, all these things came about, and the Parliament in UK is the strongest in the world. And if the law, the Constitution has given it to us, and we do not defend it jealously, then a time may come that Parliament may lose its relevance. We must guard jealously against the executive and judiciary encroaching into your closed doors business. Then a time may come, you cannot even argue, because they will come and tell us what is going on. Thank you.
Thank you, my Lord. And we will guide it jealously.
Any further question?
Yes, I have one more. I have one more. There have been two. Thank you so much for the education, anyway. Second question. There have been two conflicting decisions of the Supreme Court in respect of its enforcement and interpretation, jurisdiction under Article 2 and 130 of the Constitution. What is your opinion or position?
Thank you very much. Now, fortunately, it has come to an end, but let me state it. The Supreme Court had two conflicting petitions, but in law, when we talk about enforcement of Constitution, we are saying that identify the law, implement it, that is, identify it and implement and make it applicable. That is what we mean by enforcement. But when we talk about interpretation, we are saying that it is either unclear, ambiguous, and therefore you need interpretation, or two provisions of the Constitution which are in conflict, or the Constitution has set up a body, and the operationalization of that body cannot be done because of the provisions in the Constitution. Now, there was no ambiguity as to the enforcement or the interpretation. But Supreme Court, when it was composed or presided over by one particular judge, then the word or, enforcement or interpretation, the word or remained or. But whenever another presiding judge was on the panel, then the word or became end, according to come to the Supreme Court. But if you make it enforcement with interpretation, then you cannot come to the Supreme Court only for enforcement. It must be enforcement with interpretation. But the irony was that Osei Boatin versus Ghana Media Commission was where the two heads met. The one proposing end and the one proposing or. Then, fortunately, the one proposing end had a majority. and the one proposing or had the minority. And in his dissenting opinion, he said that I perpetually disagree. Unfortunately, the one who said end retired. And the next case that came, Call versus Attorney General. So the one who said or was presiding. So he had the majority, and he said that the word or is all. And the Supreme Court went ahead to say that all the decisions that held that the word or should be end had ceased to be good laws and should not be followed. So now it has come to an end, provided another set of people will not come and take it from another angle. Thank you, Honorable.
Thank you, sir, and I wish you well.
Thank you. I'll give the floor to Honorable Patrick Yalboma.
Thank you very much, Chair, and congratulations to Sir Dennis. Be fancy, page 18, sir. I'm going straight to the church and to the Catholic Church, of which you are very respected and knighted. I'm seeing the names of Archbishop Peter Kwesisapo. I've seen Father Campbell behind you. And I want to ask you, sir, the Catholic Church has a position on gay and lesbian rights. And you know our laws also frowns on those practices. Definitely, you've heard some of the debates and arguments on some of these things. And there hasn't been any definite pronouncement by the Supreme Court. I'm not asking for your opinion should this matter come to you, but how would you marry this issue when it comes before you? Thank you.
Thank you, Honorable Chair. Honorable Chair, we talk about our faith, it could be Christian faith, Muslim faith, it is your faith. Then when you are in the courtroom, you have taken judicial oath. That your judicial cap, you must bear in mind that you must perform in accordance with the judicial oath that you have taken. So to me, if any matter is brought before me, whether it is same-sex, whether it is whatever, when it comes before me, I will look at the circumstances, the law, and I will give effect to the position of the law, without being influenced by my faith. Otherwise, I will abdicate my seat as a judge. The African court is worse. You know, African court, we handle only human rights cases. These are some of the cases that come before us, but when they come, we handle. We don't put on our faith, because if we put on our faith, then a time may come. Every religious sect would insist that I should have a judge on this panel. Otherwise, if a case comes, I will not get what I want. But that should not be the position. Thank you, Honorable Chair.
Thank you, Chair. I don't have a follow-up question on that, but your CV said then there's nothing about sports. It's all about academic work, and book. My Lord,
what is the meaning of book and kwa? At least for the record.
Just a scholar throughout his life, and must commend the gentleman from Suurbaareh. My Lord, you've had extensive experience in judicial education in the international judicial bodies, including ICC Advisory Committee, the African Court on Human and People's Rights. How would you leverage this experience to strengthen judicial independence in Ghana? And what reforms will you propose for continuous judicial education to ensure that our judges remain current with evolving legal principles whilst maintaining...
Thank you, Honorable Chair. Honorable Chair, first and foremost, I will refer to our Code of Conduct. Our Code of Conduct talks about impartiality, independence, conflict of interest. So if you are a judge, once you take the oath, then you are bound by the judges, the Code of Conduct for judges and magistrates of Ghana. and you get all these things from it. We need to continue educating our judges and magistrates. That is the first one. Then the second one, we have the Bangalore principles of ethics, and we teach. It is an international principle that whether you are a national judge, international judge, you must know. Because it will tell you that once you are a judge, you must identify yourself as a judge, and always have in mind that the executive and the legislature should not have any influence on you. And we even go ahead, apart from institutional influence, we also go ahead to talk about individual independence. If you are a judge and you are sitting on a matter, if you allow any person to influence your conduct, that means you have lost. Well, by God's grace, I have acquired international experience from the International Criminal Court. And when I mentioned the chairperson for the African Judicial Network of Environmental Law, it was all the judicial trainers in Africa. When we met, I was elected the president. That is what it means. And I go to other countries to teach, to train them. Even Tanzania some time ago invited me to help them draft their bench. Will be able to train our judges. We retrain to the extent that their capacities will be built, and they'll be able to resist every attempt by either the executive or any other agency.
Thank you for this question. A lot of people have asked questions about the jurisdiction of the Supreme Court. We have about 7 or so. And I know sitting on the Court of Appeal, a lot of interlocutory appeals comes to you about it. Given the opportunity to sit on the highest court, which of these jurisdictions that the Supreme Court is closed with, would you propose some reforms so that some of the matters are terminated, maybe at the High Court level, Court of Appeal levels, to also help in the reduction of the workload on the Supreme Court? And on that, Sir Dennis, I wish you the very best, and God bless you. Thank you.
Thank you, Honorable Chair.
Yes, my Lord Nominee.
Honorable Chair, if you talk about the whole world, Ghana was the first country to give supervisory jurisdiction to the Supreme Court. Sierra Leone was number 2, and Philippines number 3. Throughout the world, these are the only 3 countries where Supreme Court exercises supervisory powers. If you go to UK, you go to all other countries, it is exercised by the High Court over the lower court. Because you call a court a superior court, then you are still supervising it. You know, Ghana introduced it through the 1969 Constitution. And if you look at the cases before the Supreme Court, about 40% of them are on supervisory jurisdiction. And you know, it is very broad. It is not limited to those coming from only Court of Appeal, High Court, Regional Tribunal. You can even go from a district court, for example, where a district court is interpreting Constitution. High Court cannot say that I am supervising you, because the High Court itself has also been restrained from delving into that matter. So any area that the High Court lacks jurisdiction in, and any of the lower courts purpose to do, you have to go to the Supreme Court. So now, if you go by the supervisory jurisdiction, I believe it will be okay. But the Supreme Court introduced another limb to it, interest of justice. Because we all know that wherever you go throughout the world, supervisory jurisdiction they have faced. We talk about natural justice. We talk about patent error on the face of the record. We talk about breach of the Wensbury principle. Somebody will go to the Supreme Court. You would 131 appeals. Appeals to there's a problem. Appeals, we are saying that High Court, Court of Appeal, if the case starts from the High Court or Regional Tribunal, and you come to the Court of Appeal, as of right to the Supreme Court, then irrespective of where it starts, if the Supreme Court decides to give special leave, they will give special leave. Then the other one, when we talk about the lower court, any person who loses at the Court of Appeal, you need leave to go to the Supreme Court. So the leave and the special leaves I believe you can do something about them. If we take away even special leave alone, then some of them, as is done in some jurisdictions, some of them terminate at the Court of Appeal, then Supreme Court will not be inundated with all these cases. And Honorable, apart from the jurisdictions that you have said, you know, apart from those Supreme Court, apart from those the Constitution has given, the Court Act has also given 2 additional jurisdictions to the Supreme Court. The first one, Section 9 of the Court Act, that when we are talking about prerogative of mercy, where it's not the one in the Constitution, this one where somebody petitions the President that please have mercy on me. This one, then when it is sent to the President may refer to the Supreme Court to hear it as an appeal or may give an advisory opinion. Then we talk about Section 100 of the Courts Act, reservation of question of law, where Court of Appeal is hearing a matter and the Court of Appeal is confronted with difficulties. Then they reserve the question to the Supreme Court to answer for them. And Supreme Court will answer before it comes back. So these are some of the jurisdictions that we can do away with. Otherwise, Supreme Court will continue to be inundated with cases. Thank you, Honorable Chair.
Thank you very much. Before I proceed to give the floor to Adjei Ladi, Justice Sir Dennis, we know your background as a lecturer. So we'll plead that you are brief. We have one more judge to take. Yes. So, Adjei, you have the floor.
Thank you, Chairman. Congratulations, my brother. With all intents and purposes, I just want you to explain and tell me how you would agree with the mandatory imposition of death sentence when people violate the law. Do you agree with it? Do you not agree with it? In fact, I wouldn't want the answer to be too detailed. Just.
I agree that the mandatory imposition of death sentence is wrong. If a person goes to court and the person is to be convicted to suffer death, first and foremost, we must respect life. So we must give discretion to the judge who heard the matter, either the judge to give a number of years or to impose death sentence. But if you look at the treason, high treason, and the one in the signatory to the African Charter on Human and People's Rights, and Article 4 of the African Charter on Human and People's Rights provides that you must respect life. And the African Court has variously held that any decision by any country which does not give a judge discretion in the imposition of death sentence is in violation of Article 4 of the African Charter. Ghana is a signatory. That is why I am there as a judge. And we have found several of them against Tanzania. Tanzania is the worst offender. Then we have found some of them too against Benin. So if cases from Ghana happen to be there, we are going to face the same fate. We are going to lose. Thank you.
Thank you very much.
Chairman, a follow-up on your response. I'm happy to have heard from you that we are a signatory and that you are even a member who can come up against those rulings. Will you suggest you have a committee of parliament, and even you yourselves are persons, you have individuals who can make inputs to parliament that we need to adhere to what the signatory we have appended, and that we must go by the law. I don't agree with the issue of the death penalty. I, in person, that is me. So I think I want to know from you whether you would want to take it up and that we should re-look at it.
So, my Lord, this question demands yes or no answer.
Yes. Honorable Chair, what I will say is that yes, we need to outlaw those things. And I was invited by Parliament to address them in Koforidua on this issue. And I came here to present a paper. Thank you.
Honorable Adjei Ladi, any further question?
No, please. Thank you.
Well, I will then give the floor to Jerry Shai Ahmed.
My Lord, congratulations to you. My Lord, Chairman, if, with your permission, I want 5. 1, that says that justice emanates from the people and shall be administered in the name of the Republic by the Judiciary. We shall be independent and subject only to this Constitution. I want to situate this with 1466. In your view, do you think the judiciary is really independent?
Yes, Honorable Nominee, you have the
Thank
floor.
you. The first thing is that when we talk about the independence of the judiciary, the first thing that comes to mind is the exercise of judicial power. I have final judicial power. So when we talk about the independence, the first premise is on the exercise of judicial power by the court. Then when it comes to 146, it comes to removal of judges. Removal of judges. If you look at it, it has provided that a petition, if it is against me, a petition shall be sent to the president. President shall forward to the Chief Justice. The Chief Justice shall make a prima facie case. So here, the question is, will that amount to encroachment on my core duty as a judge? And the answer is no. It will not. The fear that people entertain is that when the committee is set up, but for the judges, it is the Chief Justice who will set up the committee, then he takes other members from elsewhere, then they fall. And once they are sitting as administrative bodies, then the law is that they are not supposed to go wrong. They must be fair and candid. Because if you look at Article 23 of the Constitution, any person discharging administrative function shall act fairly and reasonably within the law. So once you go off the law, then that means you are doing your own thing. So, well, there's likelihood that it may be compromised. There's likelihood. We are human beings. But if we take into consideration by the fact that, yes, I'm a judge, I'm sitting on this matter, and this is my role as a judge, then at the end of the day, it should be based on the evidence adduced and the available laws that you must apply, and not your own opinions. Thank you.
You have any further question?
Yes. A follow-up. Thank you very much, my Lord. My Lord, so if we come on the same 146 and the responses, per the responses you've given, would you think that the president having the powers to appoint and disappoint impacts on the independence of the judiciary?
The president has the power to appoint on the advice of the Judicial Council in consultation with the Council of State and prior approval of Parliament. So it is not him alone. So if the person is appointed, then when it comes to removal, the Constitution has provided for a particular procedure. And that particular procedure, it must be followed to the letter. Otherwise, it will amount to usurping the provisions of the Constitution. So once it is followed to the letter and a finding is made, we look at who are those sitting on the matter. Are they judges? Are they independent? That is the most important thing. So if they are independent-minded people, and at the end of the day, any decision that they take is premised on the evidence, I will not have any problem with it. But if at the end of the day, the decision taken is premised on any other extraneous matters, that is where I will have an issue. Thank you.
Any other question?
That's so. Thank you very much, Mr. Chair. Honorable Nominee, what would you say about 1252, where citizens may exercise popular participation in the administrative of justice through the institution of public and customary tribunals and the jury and assessor systems? And this is against the background that some of us have seen that some assessors or jurors have sent. So in about 15 to 20 years ago, I knew some particular workers from AMA who were always part of the system. Would you say that this is a system you'd want to have a relook at policy-wise and advise, or you think that it's a system that has to be maintained?
Thank you, Honorable Chair. Honorable Chair, I have a teasation. For instance, we must know qualification, who qualifies. You must be 25, then under 60, even speak English. Then I went to some of the institutions to make inquiries. They would tell me, oh, this man is troublesome. We have sent him over there. We don't have any other person to go there. You know, we do not understand the jury system very well. Because the jury system, it is your role to your nation building. And it is peer hearing. So we want to say that there is a matter which is a very serious matter. And therefore, we want your own people to come out to say that you are guilty or you are not guilty. That is the essence of the jury trial. But if you look at the position in Ghana now, some of them are becoming professional. If you say it, they become annoyed. When I said that some of them will become professionals and we should not entertain, we should make sure that when you come, maximum 2 years, you must leave. Then at a point in time, even they met and appointed somebody and called the person a dean. And I said, you could not call somebody a dean because it is not an office. So we need to refine it. We need to refine it because we don't appreciate the essence of jury system. If you are a judge, you may do the summing up and you may think that they may either convict or acquit. Then they will come with a decision that you never anticipated. You know, at times, you look at it, and if the matter comes on appeal, at times they have acquitted the person, or they have convicted the person, and the matter comes on appeal, and you look at it, there was no justification for the decision taken by the jurors, but it has been taken. But Ghana, the only advantage we have is that we can appeal against the summons. I would say that we need to reform it, because as it is now, it doesn't help. Thank you.
Any question?
Yes.
Your last question?
Yes. No, this is a follow-up on the jury bit. It's not my last question yet. Apart from the suggestions you have made, is it the case that we should still have the jury system?
Thank you. We may continue to have it because it talks about citizens' participation, for them to understand the role of the judges, the role of the citizenry. Because once you become a juror, we call you a trier of the legal system. So when something happens on the street, they will not take the law into their own hands and delve into instant justice. That is the essence of part of jury system. But if you look at the African continent, most of them do not have. So if an empirical evidence may be obtained and we see that it has outlived its relevance, we can outlaw it. 25(2). That is why alternative dispute resolution, we get people who are not judges. We have mediators, conciliators, customary arbitrators. All of them come in to help. That is the rationale. Thank you.
Now your last question.
Yes, thank you very much. So, my last question, Chairman, with your permission, Article 15(1) says that the dignity of all persons shall be invaluable. I want to look at 15(1)(b). That says that any other condition that detracts or is likely to detract from his dignity and worth as a human being. And I'm placing this with reference to, I'm situating it with reference to where a suspect now gets some details published, maybe through a press conference, and the person gets tortured and gets very demeaned, I do not know if you would have a take, you have any advice. Would you think that is a way to go in criminal jurisprudence? Thank you.
Thank you, Honorable Chair. Honorable Chair, what amounts to human dignity, degrading, inhuman treatment, they have been discussed in all the international instruments, particularly the African Court. I can cite about 20 cases. One of them is about where you use a cane, corporal punishment, Kabalabala versus Tanzania. It has been held that if you use a corporal punishment cane to whip somebody, you subject the person to inhuman or is hungry and thirsty, and you ask the person to give statement. It is inhuman. Then we have also held that if you impose death sentence on somebody and you prescribe that either to be killed by hanging, to be killed by a gun, to be killed by lethal injection, all of them, they are inhuman. Why do you say that a human being should be killed, a human being should be hanged? So if you look at our Article 15, it is from Article 4 of the African Charter on Human and People's Rights, verbatim. So the essence is that every accused person must be presumed to be innocent until either he pleads guilty or the court proves the person guilty. Until that one, then the person should be innocent and the person should not be subjected to any inhuman, degrading, torture, or any barbaric conduct. Thank you, Honorable Chair.
Yes, a supplementary question?
Yes.
Very well.
Intimating that someone has virtually stolen or has virtually committed an offense or omission. Our way to go, or that is not the way to go?
The person is innocent. Whether you saw the person committing the crime or not, he's innocent because he has not pleaded guilty and the court has not convicted that person. So to me, to say that this person has been convicted, because the person has not been convicted, that is why in criminal law, we pass through stages. We pass through suspects. You are suspected. Then you are accused. Then you are charged before the court. It's rights, and they're also different from accused person's right. So you may say that the person is alleged to have done A, B, C, D, but you cannot conclusively say that the person has done it because there is no conviction to that effect. Thank you.
Thank you very much.
I'll proceed to give the floor
Chairman,
to
thank you.
Honorable Bede Awantanzuma Zidi.
Thank you very much, Mr. Chairman. On a lighter note, Mr. Chairman, I want to congratulate my Lord, Sir Dennis. But I'm curious. Since I have known you, I have not known you to have Dominic as part of your name. So I'm curious. I've always known you as Dennis, and I know you to be Catholic. We worship together. When I saw your CV, I saw Dominic. How come you have got two Christian names, Dennis and Dominic? I'm interested.
Is that your question?
I said, on a lighter note.
Why on a lighter note? Is there any law that prevents a person from having two Christian names?
Yes. Come again.
Is there any law that prevents a person from having two or three Christian names?
I just say that I'm curious.
Very well. Yes. Proceed to ask your question.
Yes.
Thank you, Honorable Chair. Catholics, we look up to the saints to imitate them. So at birth, I was given the Christian name Dennis Dominic. So I came to meet it. It wasn't that I took it. And I love the two names. Thank you. Because they have significance in the Catholic Church. Thank you.
Well, I'll treat that as question number one. Go ahead and ask the second question.
Mr. Chairman, I told you that it's on a lighter note. Anyway, I've come to my main question.
Ask the second question.
My Lord, we have had some challenges. We have had some challenges here in Parliament in dealing with the doctrine of separation of powers. I want you to give us some, if you like, since you have been lecturing, a little lecture of the doctrine of separation of powers in the context of the Constitution of Ghana. And in particular, my Lord, the legislature and the judiciary arms of government. Under the 1982 Constitution, it is quite clear that the judicial power is exercised by the judiciary exclusively. That is stated under Article 125. Then, in our standing orders in the Speaker, my Lord, and yet, in this Parliament, when a decision is taken or when an interpretation is given by the Speaker, a member who is dissatisfied with that interpretation or that decision moves himself out of Parliament to the Supreme Court. My Lord, is this helping us in observing the doctrine of separation of powers?
Well, Honourable Member, you have asked your question. I will beg my Lord Nominee to answer the question, but not to lecture.
So basically, when we talk about separation of powers, as propounded by Aristotle, his position was that each of them should be independent, but each of them should be independent in the discharge of their core functions, not ordinary functions, core functions. But even he referred to the executives as magistracy, but in real sense, it is the executive. So what he said was improved upon by Montesquieu. And Montesquieu said, yes, we cannot have independent, so much absolute independence. By their core functions, they should not interact. Now, from this one, then let's come to the Ghana Constitution, as you have said. If you look at the Ghana's Constitution, each of them has its core function to perform. The core function has not been given to any one of them, but by the ancillary functions, that is where others come in. So if you are debating, whatever comes up here, free speech and those things, you cannot take it to the court. But if you have a rule, and someone is saying that this rule offends this constitutional, and the people of Ghana has appointed the Supreme Court as the referee to guard the Constitution. That is why we have the Crow's Brook doctrine. That one you cannot take it. But if it is about a law, and I think that you are saying this law should be this, and I think that it violates a constitutional provision, nothing prevents me from asking the Supreme Court to make a pronouncement on it to guide us. Because the intention is not for Supreme Court to prevent Parliament from working, but rather to enrich the work of Parliament. That you were doing this thing. This thing is a violation of this. Please don't go and do it anymore. It must be done this way. So at the end of the day, all the infractions will be addressed. Thank you.
Any further question?
My Lord, I want to still get some clarification. The point I'm making is that in Parliament, we have got standing
Honourable
orders.
Adjei, please ask question.
Oh, I want to lay a
Honourable
foundation before asking the
Awantazuma Zidin, please ask question.
My Lord, is it proper, for that matter, that a determination of that issue has been made in Parliament by the Speaker, and somebody who is dissatisfied and a member of Parliament decides that he will still take it to the Supreme Court? That's my question.
Thank you. The power to interpret the Constitution, or the power to compare any law that is made in contrary to an existing law that gives you power, or to the Constitution. The law says that go under Articles 2 and 130 of the Constitution for the Supreme Court to make an appropriate declaration. So in that sense, if the person goes, the person hasn't done any wrong thing. It is within the law. Thank you.
Thank you. Any further question? No, that should be the third question.
That will be all for now.
Thank you very much. I will then give the floor to the second deputy speaker to ask one question.
Thank you very much, Mr. Chairman, for indulging me. My Lord, let me also add my voice to a lot who are congratulating you. My question is, with the inundation of so many cases at the Supreme Court, can you give your position with respect to a lot of people who are advocating that we should have a separate constitutional court to deal with constitutionality and probably leave other people to also handle other cases?
Yes.
Thank you,
Lord,
Chair.
you have the floor.
Thank you, Chair. Within the context of Ghana, I would say that we should not take that jurisdiction away from the Supreme Court, except that we should ensure that we get the adequate number of judges to sit in that court. Because if you look at the Constitutional Court, let's look at South Africa. You know, South Africa, they have the Supreme Court of Appeal as the highest court, then they have the Constitutional Court. The Supreme Court of Appeal alone is made up of 25 judges. Then the Constitutional Court is made up of 11 judges. And at times, you see that the Constitutional Court will be a bit redundant. So why do you engage 11 judges to interpret only Constitution? And when the Constitution, we don't have constitutional cases, they go to work, sit in their office, and go home. So within the context of Ghana, that jurisdiction has been given to the Supreme Court. I think we should allow Supreme Court to exercise that jurisdiction. But the only thing is that in constitutional matters, other things being equal, we can use 7, 9, or 11 judges of the court to sit, as we do in the African court. Every case, every judge will sit, unless it affects your country. In that sense, you get the blend of judges with their opinions. Thank you, Chair.
Yes, I give the floor to Honorable Deputy Rankin.
Honorable, my Lord Nominee.
What did you say?
I'd like to find out from you. You've really given us a lecture today, and I know you have a very wide span of knowledge on certain issues. But what has been your record on contributions in advancing children's rights and gender equality within the legal framework? Thank you.
Thank you, Honorable Chair. When it comes to children's rights, I've delivered several lectures on the continent, and Ghana, I've delivered several of them. Then, when we come to gender equality, gender inequality, I have published a lot on those areas. The most important thing that we must do is that we talk about human rights. Human rights encompasses bringing all people at par. So you should not sit down for one to be disadvantaged, including children. That is why, at a point in time, when people were talking about the fact that defilement should come within the pre-bargaining, I am one of those who objected to it, because we are talking about people under 16 who have been defied by people, and we are saying that if the person can pay money, the person can negotiate and pay money, then the person can be given any form of sentence. When the law has prescribed that the minimum is 7 and the maximum is 25. So I've championed a lot, and if you look at my contemporary criminal law, I've discussed a lot on children's rights, who is a child, what are the rights available to them, a juvenile, where do they go. I've also discussed them in my criminal procedure textbook. So I've done a lot of work on inequality at par, and children too are protected because they are young. Thank you.
To follow up, so if I understand you very well, if a revised bill criminalizing child marriage and witchcraft accusation is passed, how receptive would you be to its implementation from a judicial standpoint? Thank you.
Thank you, Honorable Chair. Honorable Chair, why should we at this modern age talk about witchcraft? It has become outmoded. And the only country that I've seen it in their statute is Tanzania. And whenever it comes before the African court, we condemn them. We find them to be in violation of it. Then we talk about child marriage. Why can't we wait for the child to get education, to learn trade, so that in future, even if there is dissolution of marriage, the child can survive? Now the person is 14, 15. That is why I'm happy with the laws on the defilement. Because defilement, it is neutral, with or without consent. You commit it. But there is a gap between our law. So if you are of 16, that means the person is 16 and the person voluntarily have sex. That one, you cannot blame any of the parties. But the person cannot marry until the person attains 18. So at 16, you can have sex, but until 18, you cannot marry. What happens within that period, the gap? I believe in future we can fill that gap. If you cannot marry, don't have sex. So why can't we make it straightforward, 18?
Thank you very much, Honorable, my Lord. We passed the affirmative action bill last year, July, and since you have been a trainer, or you have been in the institution of the Judiciary institution, I want to tease out your view on how you can, what do you think we should do to ensure gender parity in the Judiciary? Thank you.
Thank you, Honorable Chair. The Judicial Training Institute has capacity to train the judges. But when it comes to the training, at times we are confronted with facility cash. That is the problem that we need. Because if you ask one judge to move from Kumasi to Accra for training, the person will come with the driver. The person will come with bodyguard. How do you accommodate them? It is the cost of the judiciary. But at times, the judiciary hasn't got enough budget to undertake these things. That is why at times you see donors coming in to help. But some of the donors to their donation, to me personally, when I was the director judicial training, I rejected some of them. They will go to the CJ. Because why should you come and tell me to train judges on a law that exists in your country and it doesn't exist in my country? I will not train. So these are the important things that, so if judiciary submit budget and the training component, I will plead with budget. I will plead with Parliament that the training budget always preserve it for us so that we can get enough money to train our judges, to build their capacity so that they will be up to the task. Thank you.
Honorable Chair, let me take my Lord into the current trending global issues. Looking at climate litigation, such as, and let's look at the issue of Etiwa Forest, as the case has been limited in Ghana due to the lack of specific legislation. Would you support a right-based approach to environmental cases? And how would you balance economic interest with constitution?
At our constitution, there are two provisions which talk about protection of the environment. You will find it in Article 36. Then we also find it in Article 41. That is the rights and duties of every citizen. And every citizen is required to help to protect the environment. It is a constitutional duty. Despite the fact that it falls within the directive principles of state help protect the environment. How do we protect the environment? There are enough laws, even though we complain that there are not laws. There are enough laws. What are they, those in the Atiwa forest? What is the rationale? Ruthlessly. So we have enough laws, but what to me is remaining is about enforcement. We must enforce it. Those in the Atiwa forest, they cannot fight the entire Ghana army. They cannot fight the entire Ghana police. Why can't they arrest them? If they arrest them and they bring them to court, they are dealt with and they are sentenced to a number of years as prescribed. Here we are talking about deterrent and preventive. We achieve some of the theories in criminal law. It does not say that only police should fight. It says that every person shall contribute to the protection of environment in Ghana. Thank you.
My last question, Honorable Chair. What 3 specific constitutional amendments would you recommend to modernize Ghana's succession framework? And if I may ask, for each of them, if you can explain the current problem and your proposed solution. Thank you very much.
Thank you, Honorable Chair. Honorable Chair, my first proposal will be the district assembly. That the position now, we are saying that it should be non-partisan, but on the ground, it is partisan. Why can't we be bold to say that this is what initially we intended to achieve, but it cannot be achieved, and therefore, you can go partisan way, because that may help, because as it is now, we are saying that it should be non-partisan, but every assembly member, they will tell you that this one belongs to this party, this one belongs to this party. So that is my first one. And the second one concerns my own work as a judge. Judges sitting in court as additional judges. That one should be abolished. Judges sitting in court as additional. Because it is not done in any country. It is not done in any country. We have enough high court judges. Why is it that if there is a case to be tried by a high court judge, we ask a court of appeal judge to go and sit? We have enough circuit court judges. Why is it that if there is a case before the circuit, we ask a high court judge to go and sit as additional? You know, that one, we are talking about human influence. And we must reduce it. We must curb it. I have examined almost all the constitutions in Africa. And I haven't seen in any country where they ask judges to go and sit in another court as additional. So if we do away with that one, because always when a judge from a higher court goes down to sit on a matter, the impression is that they start talking about bias, whereas we have enough judges for the same court. So to me, that one should be abolished. It is my own opinion because of the constitutional analysis that I've made. I think it should be abolished. So having said about these two, I think it is enough. Thank you.
Thank you very much. I wish you the best of luck. Thank you.
Thank you. I'll proceed to give the floor to Honorable George Kweku Ricket Hagan, the Vice Chairman of the committee.
Thank you very much. Sir Dennis or Lord Dennis, I'm sure each of them will go. Congratulations. My question will be an expansion of the question that Mr. Speaker, and that is Second Deputy Speaker, asked. And he was looking at whether there should be some additional courts, the constitutional courts to deal with issues. But I want to look at the entire court system or the entire judicial system. there are a lot of complaints that there are a lot of cases building up in our courts, and that some of the reasons is that we don't have the manpower to do the work, or there are some inefficiencies that need to be worked on. There's another school of thoughts, fully, or at least to a greater extent, and that is to bring in that the functions of the court were mainly based on some kind of a database systems and management to be able to move things much quicker, in the court. We do say that the wheels of justice grind slowly, but it looks as if things are grinding much more slower than they should. In your view, would you also share that view that we need to automate our courts or computerize our court systems to become efficient enough to move cases much faster than they are being churned out at the moment? Thank you.
Thank you, Chair. The court has passed through several stages to ensure early disposal of cases. We started with the scoopists, that they will move fast. Then at a point in time, we saw that the scoopist work was automation. Automation, at times, staff will be working and the light will go off. The court becomes a standstill. Now, the aim of the judiciary is to achieve the e-justice. And the e-justice, you cannot achieve the e-justice where you do not have dependable internet. Because number one, e-justice, we start with e-portal. Go to the website, you'll find everything that you need. Then after e-portal, then you move on to the second one, e-forms. When you need the forms, you just go and print. Then e-filing, you use the same form to file. Then after e-filing, e-case distribution, there will be no manual for the head of the institution to say that you judge, go and sit on this one, you judge, go and sit on this one. It should be automatic distribution. But we do not have all these things. Then after that one, then we move on to e-evidence. We take evidence, then we do electronic hearing. Then we move on to electronic judgment. We've been talking about e-justice, the E8. As at now, to me, I don't think we have even achieved 2. So we need money to overhaul the digital system of the judiciary to enable us to use the equipment to dispose of cases expeditiously. Otherwise, manual, if you go to some places, you see handwriting. It takes some time. Then at times, apart from the handwriting, you get interpreters. All these contribute. So I think that it is the wish of every judge that the court will be fully equipped with the E8. When we have, it becomes even a joy for you to work under such circumstances. Because if you come to the African court, for instance, and we are working very, very fast, the number of decisions, even though apart from the president, the 10 judges are part-time. If I tell you that 1 year, we can deliver about 36 judgments within 4 months. So it is the wish. And I will still plead that Parliament, when we present our budget, please defend for us, don't cut, so that we can help to promote expeditious disposal of cases. Thank you.
Any further questions?
Yes, Mr. Chairman, one more question. And this one is actually on a lighter note. I'm a bit curious about this. You realize that most of our courts, the ones that I've seen and ones that others have been, again, you did talk about energy, of course, power issue. But we tend to have, a lot of our courts don't actually have air conditioning or AC and these things. Where we have them, They don't work. But then we continue to wear our gowns and our wigs. So I'm wondering, I know it's a colonial legacy that the institutions like the Judiciary got seriously. But you realize that the Speaker has taken off his coat, and so are the other, the first and second speakers, and including the clerks. Don't you think the gowns, though they are legacies that maybe we treasure, it's a bit outmoded, that we should maybe start putting on our traditional stuff like the Speaker and others are doing? You know, these things will be much more practical, or these clothing will be much more practical for our kind of climate than the colonial gowns that we continue to put on, and probably use them on ceremonial basis like we do in Parliament today. Thank you.
Thank you, Honorable Chair. Honorable Chair, the wig and the gowns, they have several significance. They have several significance. Now, there was a proposal that we should not be wearing wigs and others. And we found, in addition to what I'm going to say, we found that some people, I'm Dennis Adjei, appearing for this one. But if you talk about Parliament, Parliament is just one. Speaker is just one. So I'm happy that Parliament has taken the bold decision. But for the Judiciary, wherever you go, every court has its own robe. All the international courts, all the national courts. So to me, my policy is that, after all, it doesn't take away anything from us. It doesn't take away anything from us. What it does is that it sets you apart, that this is a judge. Look at with its wig and gown. So to me, I treasure it. So, Honorable, I will not support your position. Thank you.
Thank you very much. I think that we need to repair the air conditioning.
Honorable members, lawyers who are wearing the opportunity of wearing them.
We see you sweating.
Yes, it's now the turn of Osahin, Togbi Osahin Alexander Kwamina Afenyo Markins, the ranking member of the committee. You have the floor.
Lord, in 2023, did you do part-time teaching alongside your judicial duties?
Yes, please. Whenever I'm in Ghana, the law school, I teach. I teach. Initially, I used to teach the entire part too.
My Lord, I would crave your indulgence to give me direct answers. So I repeat, my Lord, in 2023, did you do part-time teaching in Ghana?
Yes, please.
In 2024, did you do part-time teaching in Ghana?
Yes, please.
Please, in 2023, the part-time teaching you engaged in, were you remunerated?
Yes, please. But if I tell you some of them, you will laugh.
Oh, don't worry.
Yes.
What about 2024?
Yes, please.
I have with me a GRA tax clearance certificate you brought to us. Your TIN number GHA 711947735/0. It bears the name Dennis Dominic Adjei. And the purpose, it says year of assessment 2025, and purpose to support my nomination to the position of Justice of the Supreme Court. I would like to know from you, by the way, do you have a copy of that tax clearance certificate with you?
I may have the soft.
May the clerks supply the nominee with a hard copy of what he has furnished the committee, please. My Lord, please, are you in possession of a copy of your...
Yes, please, I am.
Very well. Now, in obtaining this tax clearance certificate, I want to know from you whether you did the computation of your tax obligations yourself or that of the Judicial Service for them to forward your details to GRA for the purpose of obtaining this.
Thank you. I forward to the Finance Division of the Judicial Service, and they know all the schools that I teach. So they take all of them into account, and they tell me that when, how do you even call it, the VAT and others from it. So this one was obtained this year, but every year I do that. Thank you.
My Lord, you went ahead so that there will be clarity, you know. So you forwarded your details to them, the Finance Department of the Judicial Service.
Yes, please.
So regarding whatever computation they did with GRA, you were not privy to it.
After it is prepared, they bring it to me for my signature, and I sign.
Now, when they brought the document to you for you to sign, did you really pay attention, or you assumed that as professionals they've done the needful?
I presumed that the writing has been done.
All right. My Lord, that being the case, I will want to strongly suggest to you to get back to them so that they add your other remunerations. So, in other words, it does not constitute a full disclosure of your... Urge them to do the full disclosure as you provided them. Is that okay by you?
Yes, Honorable, it's okay.
All right. Really could have cost you some...
Honorable, thank you. Honorable, I tell them to prepare, and for my house, the rent, I pay the rent tax myself, and that one, they disaggregate from this one. That is why I did not cross-check whether it has appeared on that one, so thank you.
Yeah, but you don't have a separate tax certificate regarding your rent tax or whatever you're talking about. I'm talking about your earnings. So you may go back to them if you want to assure this committee that you will do that needful. The records would permit you, and with the leave of the chair, so that we don't drag this.
Thank you, Honorable. I can do it. Even tomorrow, I can go there.
Yeah, what I'm saying that you have to, procedurally, yes. I don't have the powers. The chair must grant you the leave. So then I would not pursue this with the assurance given with the leave of the chair.
Honourable members, the witness or the nominee is telling us that he's been paying the rent component of the earning directly. And normally, the GRA will consider matters as a whole in issuing the tax clearance that is here. You may say so, then I can then use my discretion to decide whether to grant leave or not to grant leave.
Honorable. 。
Granted. 。
Honorable, 。
Granted. 。 .
。 . 。 . . . . . . . . 。 . . . . . 。 . . 。 . . . . . .
。 Granted.
Honorable nominee, let's do some little exercise on your CV. Page 8 of your CV. On page 8 of your CV, you have honorary position. And you state, quote, knighted by His Holiness Pope Benedict to the Order of St. Gregory the Great on the 18th of October, 2005. I presume that it is this honorary position that your title, Sir Kamet, correct?
That is so. It goes with title.
Very well. So, this Order of St. Gregory, is it a fraternal society within the Catholic Church?
No, priest. It depends on the services that you have rendered. They look at three things: your contribution to your country, your contribution to humanity, and your contribution to the church. Then they make recommendation to Rome for Pope to consider. So if the Pope deems it fit, then the Pope may knight you into any of the categories. Thank you.
When you say any of the categories, what exactly do you mean?
We have the Equestrian Order. We have St. Gregory the Great. We have St. Sylvester. We have multiples of them.
But in Ghana here, your journey in Christianity within the Catholic Church, do you belong to any of the fraternal orders in the Catholic Church of Ghana?
That is so. I'm a member of Knights of St. John International.
Now, you would agree with me that a person who is a Catholic and not a member of that lodge is not admitted into its assembly and its practices. You'd agree with me?
About thank you, Catholic Church. We don't have lodges. We have the Knights, either Knights of
The
Marshall.
fraternal order, correct? It's a fraternity.
It's
outside of the Catholic Church. So,
Honorable ranking
talking
member,
about his CV.
just calm down. The witness is telling you in the Catholic Church they don't have a lodge, they have knights. So please take the answer.
Chairman, Honorable Nominee, you would agree with me that those who do not belong to that fraternal society in the Catholic Church and do not know your practices and your value system often criticize what they don't know. You agree with me on that?
That is so.
And for your lifetime, such nature, you would agree with me?
That is so. At a point in time, somebody died. We went to bury him. We went to bury the person. They thought we were coming to resurrect the body. I saw them lying, so I invited all of them to come because.
Honorable Nominee, if you say you are praying for the disease, but the priest, I believe that the priest had already prayed and performed those burial rites. So your fraternal group would also do further praying?
That is so. We don't have limit to prayers. If I get even 1 million people praying for me, I'll be happy. So that is why even our deceased brothers and sisters, we continue to pray for them. And we have a day that we remember them. We call it Memorial.
Let's go back to page 2 of your CV, please. please clarify for me. What certificate do you have for your first degree?
Bachelor of Arts, Law and Linguistics.
Would I be wrong to say that it has that Law and Linguistics, Bachelor of Arts, Law and Linguistics, has the same value as LLB? Would I be wrong to say that?
They had equal admission to the law school. So I would.
Now, clarify for me again. You have stated qualifying certificate in law, and you indicate 1991 to 1993. If my math is correct, that's 2 years, correct?
That is so.
For what I know, this Makola Ghana School of Law, the professional law, is 2 years, part 1 and part 2. Is that what you are describing here?
That is so.
So do I take it that having attained BA, Law and Linguistics, you were given an exemption not to pursue any LLB or do what they call the qualifying certificates in law prior to doing the professional? Because just by way of background, when you don't do LLB and you do BA, you would have to, before you do the professional. I want the clarification. I don't know whether during your time, the situation was different.
Honorable, during my time, the situation was different. Number 1 to 60, LLB and BA, all of you will go to the law school. There wasn't any distinction that because this one has done this, you need to do this. And it was 2 years.
No, I want some clarification again, please. Help me. So, your time, we had mainstream LLB students at the faculty, right? Who pursued the LLB. And from what you are saying, those of you who did BA, law and any other discipline, linguistics, psychology, etc. If you say 1 to 60, what exactly do you mean?
When you go to the first year, the entrance, the exam that we did at the end of the year, they will take 90 students during my time. They will take 90 students. Then the first 1 to 40, they will do LLB. 41 to 60 will do BL. All of them will go to the law school. 61 to 90, they ask them to do the 2 other subjects that they did.
Okay, so in other words, those of you who did BA, though not strict LLB, were added to still pursue the professional law. That's the point.
Yes, it was a matter of course.
Okay, very well. Now, Honorable Nominee, if you eventually get confirmed, how many years are you going to be on the bench to retire?
Close to 9 years.
In other jurisdictions, specifically the American Federal Supreme Court, there is no such retirement until death or resignation. There is this call for us to amend our constitution to extend the retirement age of Supreme Court judges. What is your own view on that?
Thank you, Honorable Chair. Honorable Chair, the U.S. system is a bit different. When you are of 65, you can take a senior judge status. So in that sense, you may decide to sit either 1/3 or half of your volume of work. They have senior judge status. And if you become 80 and 90, the number of cases that you will sit on, you decide, and it is given to you. That it is for the whole federal court, from the district court, circuit court, and the Supreme Court. You know, they call their high court district court. So district court, circuit court, and the Supreme Court. They call it appointment for life. But Honorable Chair, just 2009, the UK, they have increased the retirement age of their Supreme Court judges to 75. But for me, I think in Ghana, the 70 is okay. Because people go home within 2 years, they die. Because of the volume of work that we do. Thank you.
My Lord Adjei, you have made a very profound statement this afternoon in response to a question regarding judicial precedents, judicial decisions. And you made reference to this end-all concept where, according to your explanation, because of the judicial position taken by the presiding judge in a particular matter, the all was defined in a certain manner. And later when he retired and the end group also took over, that one was stated to be the old law and the new one was to take precedence. I agree with that. That's the general position of the law. Now, until 6th of May or so, the general belief was that when an injunction application is filed, once a party in that litigation is served, it operates as a stay until the matter is dispensed with. But my Lord Kulendi, in the recent 3-2 decision in the matter of Kowasifwa, has put that matter to a peaceful rest, to the effect that there must be an express order from the court. And it is that express order that can restrain a constitutional body or statutory body from acting in a certain way. Would you be of this new school of thought, or you remain with the old position of the law? I want to know, you are an academic. Let me hear from you.
Thank you, Honorable Chair. Honorable Chair, there are two positions at common law. At common law, one of the schools will hold that if the application is filed and it has not been granted, it does not constitute injunction and contempt cannot be founded on it. Then the second school is saying that if an application is filed against an act to be done and it is filed timeously, then the person must hold on and wait for the outcome. So there are two positions. So if Supreme Court has taken one of them, then that has become the position in Ghana, because there were two unsettled positions.
So now, express injunction is the rule. Mere filing and service is not, because, my Lord, now, I say this because in the Ablekuma North case, the Honorable Minister of Interior, when he was invited to appear before Parliament, to explain why the security had failed to provide assistance to EC to enable them to complete. His answer was to the effect that the security services, fortified by the court's pronouncement, to the effect that once they have been served, they have to hold on. So he justified the point that because a party in that EC collation process had filed a process in court, they felt injuncted because they said they've been served. So EC itself was injuncted, although there was no express injunction, just the service of the process. So I would want to find out from you, you are going to the bench. How do you reconcile? Because these are two issues, and they all have national significance.
Honorable Minority Leader, with all due respect, the nominee is seeking for your approval in order to go to the Supreme Court. He is not yet a Supreme Court judge. We cannot get him to constitute himself into a Supreme Court judge to be commenting on these matters. Two, by your narration, you indicated clearly that the matter is before the court, and somebody feels that I have been injuncted by a mere filing of the injunction application. Who knows that if you give him the nod, he may be one of the judges who will have to sit on a contempt issue. So getting him to make comment at this particular level, I feel strongly is outside the scope of questions that we should be asking the nominee. So I humbly plead that we move from that line of questioning to any other area.
My Lord, I've heard my chair. I want to give my chairman the benefit of doubt that maybe I didn't situate my question properly for him to appreciate it. But the whole exercise here is to hear your views on matters of law and national importance, public policy matters. And we are not asking you to make a judicial pronouncement. That is the point here. So I don't get it, but I would frame it differently. My Lord, the Ablekuma North Declaration, according to the records of Parliament, coming from the Minister of Interior, the Ghana Police Service is unable to provide security because of the presumption that a party has filed a process at the Supreme Court. And to the extent that that process has been served on EC, the security services have been advised that it operates as a stay. Hence, they are not providing security until the matter has been determined. My question to you is that, what is your own view on this presumption in the light of the Eko Asifua case, where the majority of the court, speaking through the respected Justice Johnny Kulendi, stated that it must only be an express court injunction to create that estoppel rather than relying on a mere filing of the process.
Thank you, Honorable. Honorable, you have even stated that Supreme Court has decided. And when Supreme Court has decided, whom am I, an ant, to say that Supreme Court has said this, it should be this? So once there's a definitive pronouncement by the Supreme Court, then it is binding on all of us until it is varied. Thank you, Honorable.
Thank you, Mr. Chair. Mr. Chair, what I want to know from Nominee is that as a jurist himself, and fortunately, you are of about the estoppel imposed as a result of the judicial pronouncement. Here, we are discussing opinions and views. Okay? You are not sitting as a Supreme Court judge. In fact, even if you go, if you are confirmed and you are there, you are presiding on a matter, you would have the opportunity to express a view, whether you agree or disagree with that position of the law. You may be in minority or still join the majority. What party do you hold the view that it should operate as a stay in the absence of an express judicial order?
Honorable Minority Leader, with all due respect, the nominee has stated clearly that once the Supreme Court has made pronouncement on the matter, who is he? Significant of the fact that he doesn't want to comment on matters that the Supreme Court has made pronouncement on. So let's make progress, I beg you.
Chairman, with respect, we've had a beautiful day. I expect you and I to appreciate the angles we take on the matters. I have understood him. He says he doesn't want to go there, and I have understood him. I agree. Now, I put the question differently, that at this point, I am soliciting his view on a matter. I'm not saying that he should go and criticize his colleagues who are there. I'm not saying that. Neither am I saying that he should sit here and overturn a judgment. I disagreed with the position of the majority. But in my recent review application on the House floor, I quoted it copiously because I'm bound. That is the law. And that is what I use in my review application to challenge your earlier ruling sustaining the preliminary legal objection of Honorable Ayerga against my motion on sub judice. I quoted, I relied. The cameras were there. The records of Parliament will bear me out. I am bound, and I agree with you. But it is not that path we are taking. I am asking that as a judge, as someone who teaches the law, what is your view on these schools of thought? Do you believe that there could be some exceptional circumstances where service of the process must operate as a stay and not to wait for express judicial order to restrain the person? I just want to know your view, but not to attack
With all due respect, the nominee was clear in the answer provided that once the Supreme Court has made pronouncement, the word he uses, who am I? So the Supreme Court has stated clearly what is his opinion as compared to the judgment delivered by the Supreme Court. Let us be very careful so that we don't constitute the nominee's vetting to sit as a court to either review the decision of the Supreme Court or comment otherwise on the decision of the Supreme Court. That is where we have to be very careful. That is what I am drawing your attention to.
Mr. Chairman, the whom am I phrase he used was in respect of he having the power to overturn that. We are not in that space. That is not where I am. The subsequent question that I framed was in respect of an opinion, in respect of the two schools of thought on this subject matter, not for him to attack the judgment. And I agree perfectly. That's not where I'm going. The gravamen of my question is, where do you stand in the two schools of thought? If I have to clarify, where do you stand in the two schools of thought?
And somebody is bringing an injunction against Parliament from discharging its constitutional mandate. I will not say that the fact that it has been said, EC, don't conduct presidential election. Then the EC says, I'm not going to conduct by the service of the application. That's when it will create anarchy. So even the two schools of thought, we need to treat it case-by-case basis. Thank you.
My Lord, may we... I'm happy with this. It's a matter of case by case. It's not a rigid thing where you say there's an absolute position and all. And I'm satisfied. Thank you. My Lord, may we do a little exercise on Article 1442? My Lord, does my Lord have his constitution by him?
I've been given one.
And you have the 1442. You are there with... My Lord, if you may read that aloud for us.
The other Supreme Court justices shall be appointed by the President acting on the advice of the Judicial Council in consultation with the Council of State and with the approval of Parliament. Thank you.
Okay. My Lord, I'm going to give you two practical examples, and I would put my question for you to express a view. So I claim your attention. First, I shall refer you to a letter dated 30th of May, 2024, written by Her Ladyship, the Honorable Chief Justice, Araba Isaba Tokonu, and the letter is addressed to His Excellency Nana Addo Dankwa Akufo-Addo, former President, Jubilee House. Proposal for appointment of 5 judges to the Supreme Court. Quote, I write to respectfully request that the following judges be appointed to the Supreme Court of Ghana, and a list of 5 are there. Then it goes on to say, well, I don't want to go down there. The operative phrase that I would want you to pay attention to is, I write to respectfully request that the following judges be appointed to the Supreme Court. I repeat, I write to respectfully request that the following judges be appointed to Supreme Court of Ghana. Now, this letter from the Honorable, I have 2. You want it? Oh, okay. I thought it would be a waste of time, but Chair direct that I read the document as a whole, which I will do, don't worry. So I would now go over. I write to respectfully request that the following judges be appointed to the Supreme Court of Ghana. 1, Her Ladyship Justice Angelina Mensah Homia, J. His Lordship Justice Eric Cheba for J. His Lordship Justice Edward Amwakwa Santi, J. Her Ladyship Justice Sarah Pamela C. A. Kranti, J. Her Ladyship Justice Ifia Sewa Ifia Asaribotwe, J. Then goes on. Justice Asante's term of office at the ECOWAS Court ended on the 31st July 2022. He was requested to remain at post on account of the withdrawal of Mali, Guinea, and Burkina Faso from the community. His current tenure is expected to end in 2026 or earlier, where he is expected to return to Ghana's judiciary. Now, this letter was publicly construed to mean that the Chief Justice was interfering with the powers of the president as contained in the Constitution, and received a lot of criticism. 1. 2, to nominations to the Supreme Court has been that nominations come from various states, does deliberations on these nominations, and makes a recommendation to the president for the final decision of appointment. Now, in the recent appointment of 7, of which you are included, there was a directly affected the appointment and urged upon the Judicial Council to advise. My Lord, with these 2 scenarios given you, I want to ask you, within the context of the provision in 1442, which you've already read, and at the risk of being repetitive, I would go over, that other Supreme Court justices shall be appointed by the President, acting on the advice of Judicial Council, in consultation with the Council of State, and with the approval of Parliament. How do you place on the advice of the Judicial Council? Is it the case that they will nominate for final appointment as was contained in the decision of the Supreme Court in the matter of Ghana Bar Association against the Attorney General, when my Lord Mafusao, my Lord Apau, and my Lord Puaman were eventually appointed out of the 4 recommendations made? Ghana Bar Association took issue with the presidency that, look, Judicial Council made a certain recommendation in an order of merit, and it was Mensa Bonsu, Mafusao, Apau, and Puaman, but the president took from the bottom 2. How do you reconcile all these scenarios within the context of, upon the advice of the Judicial Council? What is the function of the Judicial Council in this whole process, in your view?
So
thank you.
My Lord, from all that you have said, what really is the question? The functions of the Judicial Council in appointment of judges, is that it? No, Minority Leader. Is that the question? Yes. Very well. Proceed to answer.
Honorable Chair, I know about the case because at that time I was the president for Association of Magistrates and Judges of Ghana, so I know much about that case. What happened in that case is that the president brought 7 names to be considered. Then Judicial Council added 2 names. Then the bar brought 2 names, and the Judicial Council conducted interview, and at the end of the day, they concluded that their nominees had been. Once he has gotten Justice Yawape and Puaman out of them, he will swear them because he has not nominated them. The law says he should nominate. So Nena Megache, then Nena Megache, now Justice Nena Megache, Justice Amenuvo, and Mr. Frank Beecham, they brought an action against the Attorney General. And the Supreme Court, the majority decision by Justice Atuguba.
Malo was part of the case. It
Yes.
wasn't majority, it
Yes,
was unanimous.
Unanimous.
Yes.
What Justice Atuguba said was be endorsed by the president or must stem from the president. So this one, once it was not made by the president, it does not bind the president. That was the Supreme Court decision, which binds everybody. Thank you.
My Lord, I do not want to have a disagreement with you on this, but maybe sometime we all, I was counsel for a plaintiff who was challenging the appointment to the EC. So we had a consolidated case. I respectfully, and I do so in all modesty, the government of that decision was to the effect that to the extent that the Judicial Council had made a recommendation of all four to the president.
Honorable Minority Leader, sorry to interject. The rules are clear. When questions and asks and answer provided, you do not argue, you don't offer an opinion, and you don't address. So please, ask another question.
Chairman, let's make this exercise as interesting as possible. Let us help shape the public discourse in a very coherent manner. All that you said is not what I am doing. My Lord has stated a view on a judgment that as a lawyer, I really was part of. If I am seeking to clarify, I've not gone out of the rules. Please, you must also, please, respectfully, pay attention, hurriedly rule me out of order or say I am saying something different. I am
So
making
ask your clarification
Sure,
question.
that's exactly what I'm doing.
Yes, ask clarification question.
Honorable Bid, please. Bid, you've had your time. Bid, please, don't do that.
You are entitled to ask
Bid,
a question for...
Chair is directing affairs. Please stay
Honourable members,
Stop.
You are entitled to ask a question to clarify.
You don't have
But
a better
the
personal
comment-
relationship with
the
my Lord
com-
Dennis
the
Adjei than I.
comment-
Stop it.
The comment,
He knows me.
the
Please,
argument,
stop
the
it.
sharing of opinion is what the rule says we cannot do regarding questions.
One is entitled to provide clarity. It also helps the discourse. My Lord, like I said earlier, the government of that decision was to the effect that to the extent that the Judicial Council had made a recommendation of all four, it doesn't matter the order of merit. It doesn't, whether from the bottom, in the middle, or whatever. That is it. And I remember the end phrase of my Lord the Tuguba was that mutatis mutandis, the case is dismissed. And we all laughed loudly in court, and then we walked away and thanked the bench. Now, you have given some explanation to the scenarios I've given. I want to know from you specifically, what is the opinion you have on the phrase, the president acting on the advice of the Judicial Council? The context of this phrase in the provision. What meaning do you give to this?
Thank you, Honorable Chair. Honorable Chair, for Ghana, as I said, that is the decision that has been rendered by the Justice Atuguba. I remember your case, but because it was consolidation, each of them maintained their identity. So now if you read, you will still say that it is different from yours because it was consolidation. And in the judgment, you read them independently, the conclusion. Now, this is how Ghana has construed it. We have the same provision in Sierra Leone. But the Sierra Leone one, the same provision, word for word, they are saying that the Judicial Council, which has the Attorney General, may liaise with other stakeholders and come out with names to be considered by the President. That is for Sierra Leone. But Ghana, this is the interpretation that we have given, and it is binding on me. Thank you, Honorable Chair.
Thank you. Yes, you have the floor.
My Lord, I want us to deal with statutory construction, and executive discretion. You had earlier on talked about enactment, press freedom, and you made it clear that some of the enactments on communication law, electronic communication makes provision for some penalties that criminalizes it, although it's still seen in the context of free speech, but it has criminalized it. Now, this one, I'm relating it to the Minerals and Mining Act and our Immigration Act. Now, when laws provide both criminal penalties and deportation powers for the same conduct, which of them would take constitutional precedence? Can the executive choose administrative remedies over legislatively prescribed criminal sanctions? In the case of a foreigner, that we will not prosecute, but we are going to exercise administrative discretion of deportation.
Honorable Chair, I don't know the context, so I will be at large. What I will say is that where the law prescribes that if the person is convicted...
Then let me limit you to help. Let me give you the specifics so that you don't have to spend a whole period. Does that work with you? Very well. So, my lord, on this issue of illegal mining, we have citizens of Ghana who are caught, arrested, and they face prosecution. Government announced that for foreigners, they will invoke their executive powers given them under the Immigration Act to deport them. What I want to know from you is that, in view of the law criminalizing the action, the conduct, can there be an administrative remedy over a legislatively prescribed criminal sanction? Can that take precedence over the criminal sanction provided for by the law merely because the person is a foreigner?
No, Honorable. But Honorable, the thing about the thing about criminal law is that the state exercises eminent power, because the state may decide, that even enter no prosecutor, don't do this. So that power, even though it may not be palatable, it may not be acceptable, once the executive has the power to control criminal proceedings, it may do it.
My lord, do you think, from what you've just said, would you want to suggest to us that there are constitutional limits on prosecutorial discretion when statutory criminal penalties are mandatory rather than executive discretionary powers being exercised? Is that a suggestion?
Honorable Chair, what I'm saying is that the power to prosecute is vested in the Attorney General. Attorney General may decide to prosecute or not to prosecute. Somebody may be a thief. The person might have been seen holding something, but the Attorney General says, I will not prosecute you. You cannot compare Attorney General to prosecute. That is what I'm saying. But I'm not saying that I am a legal interpreter. I can resolve it. Thank you.
Yeah, so, my lord, that we are caught in the act of illegal mining. Because I'm a citizen, I am facing prosecution. Because another is a foreigner, the executive directive is that we should invoke the Immigration Act that allows for the prosecution. Discretionary power of AG to prosecute or not to prosecute. But I'm juxtaposing this against the idea that, well, somebody is to be prosecuted if he's a citizen, but a foreigner, we should go for deportation without prosecution. I think that's the mainstay of my question.
Honorable Chair, thank you very much. Actually, let me be honest, I don't know the circumstances that led to the deportation. That is why I don't want to commit myself. I don't know when it happened. I'm not abreast of the facts.
I can update you. I can share with you.
All right.
I can share with you. So recently the Interior Minister announced that for foreign nationals who are caught in galamsey activities, the decision of government is to the effect that instead of prosecuting them, they will be deported. It is on that basis that I am teasing out this question of where there exists prosecutorial discretion. Would we want to, at the same time, deny ourselves of that and go for an executive discretion that denies us the opportunity to punish for that offense?
Honorable, if I understood you to do that, am I right?
Exactly so.
Good. If it emanates from a law and
the executive, the enactment allows the executive to deport.
Thank you.
Not for the purpose of the offense. Not for the purpose, that allows you to deport. The executive can choose to deport anybody without giving reason. That's what I'm referring to.
In the eyes of human rights, you cannot deport somebody without assigning reason. Even if the person is illegally present in Ghana, you must assign reason before you can deport, because there are several cases in the international court where states have deported people and they have been held to have violated the rights of those persons. So even if the person is wrong, the person must know why that person is being deported. That is the first thing. Then the second thing that I would like to say is that the power to prosecute is with the Attorney General. So if the Interior Minister is saying that I am deporting them, Attorney General, I will not allow you, then the Attorney General may say that for me, an offense has been committed. I think that there is a case for the person to answer. I'm going to prosecute. That is what can be done. Apart from this, I don't think I can proffer any opinion. Thank you.
My Lord, let me take your view on Article 66 of the Constitution. On Article 66.
Personal understanding is that there is no ambiguity, and therefore no president can go for more than two terms of 4 years. To me, I don't see any ambiguity, either from literary point of view or from the purposive point of view. I don't see any ambiguity.
So this argument that if it's not consecutive, it means that there has to be an interpretation to it and all. You think nothing triggers any interpretation?
Well, to me, no. It doesn't generate any interpretation because there is no ambiguity on the face of it.
Please, have you heard Professor Kwesi Prempeh, the chair of the Constitutional Review Body? Have you heard his view on Article 66 recently?
No, please.
You've not heard his view?
No, please.
Okay.
Maybe I wasn't in Ghana and I haven't read it.
Very well. Very well. Anyway, he expressed a view not different from yours. He said the 2 terms is 2 terms, and it cannot be consecutive or otherwise. 2 terms is 2 terms. So I think he agrees with you. I mean, you and him have the same view. Thank you. Now, let me deal with issue of due process requirements. Where we have deportation powers. And would you hold the view that in the absence of due process, where the underlying conduct constitutes a criminal offense, one cannot sidestep this and move away to directly deport a person.
Honorable Minority Leader, please try and one up before 6:30 in view of the fact that we agreed to take another nominee.
Chairman, with respect, I am asking my questions. If at any point you want to stop me with the exercise of your powers as chairman, you can, and I will not protest. So I will ask my questions. I'm not done. But if you think you are the chair, you have the powers, let history record it, and we would comply with it. So let me finish my questions.
With all due respect, you have 6 more minutes. You have 6 more minutes.
Chairman, no problem. You get to where you want to stop me, you can stop me, and I will not challenge you. Honorable Nominee, principles to address cohabitation disputes. What is the appropriate scope of judicial equity in family law cases involving cohabitation?
Honorable, cohabitation in respect of property acquisition, it is treated as people who have acquired properties, but not within the context of marriage. You can acquire property with a friend. You can acquire property with a girlfriend. You can acquire property with anybody. When it comes to dispute, the question is who provided the money that was used to acquire the property. It will be based on evidence. To say that I have befriended you, we have cohabited, and therefore you have put up a house, and I'm entitled to this, will not fly, because the law is that even enemies can jointly acquire properties. And when there is a dispute, we must determine the contribution by each one of them. If it is determined and there is no contribution, you go home peacefully. Thank you, Honorable.
Honorable Nominee, for the purposes of due process and certainty, would you propose that a law be enacted to regulate Article 146 of the Constitution?
Thank you. I think if you get either a statutory instrument or CI, it will help.
Now, upon your reading of the Constitution, would you say that there is any provision that prohibits same-sex marriage?
Honorable Chair, as at now, there's no matter that I'm involved or I'm writing on. So on the face of it, I cannot say that it is either this or that, because if there is a matter or I'm writing an opinion, that's where I can. Because just to say that on the face of it, there's no sense, I think I will not act as a professional judge. I'll be acting in vacuum. Thank you.
Now let's go back to Article 144. We're talking about presidential appointment of Supreme Court justices with advice of the Council of State in consultation with the Judicial prior parliamentary approval. Would you want to precisely define what your understanding of consultation in this context mean?
We have 2 words here, advice and consultation. Advice has been held to be stronger than the word consultation. Advice they must offer, even though it is not binding on you, you must. Consultation, you can just meet them and say, I have A, B, C, D. These are the CVs. What is your opinion? And if they say yes, you may go ahead.
If they say no?
The general law is that once it is either an advice or consultation, if they say no, they must justify why it is no. But if they say no, that one you cannot proceed because they are advising you against it, or you need my consent, and I'm saying that this one I will not give you consent for the appointment. Thank you.
So your view is that where it is a no, the appointor cannot proceed. That is your view.
Yes, and if reasons are assigned why you do not, why you think that I should not appoint that person. Example, if it is a personal hatred, you went to court and you had a matter before the court and the judge ruled against you. You cannot use this one as basis. Thank you.
Honourable Minority Leader, with all due respect, may you please ask your last question so that we can make progress.
Honorable Nominee, Chairman, I disagree with you, but I will yield to your authority, please. Honorable Nominee, the Constitution and Article 146 has provided for what is known as stated misbehavior. It permits a removal of a justice of the Supreme Court without defining the term. In your opinion, what would you consider to be stated misbehavior that would guide the exercise of such powers by the authority?
Thank you. Thank you, Chair. Chair, even though you say that the Constitution is still generous, and therefore it is not advisable to borrow elsewhere, where you can interpret it within the context of the local materials. But in some cases, you may need inspiration from other countries. There are several jurisdictions that the word misstated misconduct have been established. So you may, thank you.
Yes, I agree with that, but do you have your own view on this stated misbehavior? Because you are a member of the bench, would you want to express a view, I mean, outside of look at it from the ethical point of view or a criminal conduct?
Thank you, Honorable. If we look at the law, it talks about misconduct. And misconduct, it doesn't say criminal misconduct. So it could be either criminal or civil, depending on the behavior of that person. Example, if I'm a judge, then, Honorable, you appear before me in court. I said, leave my court, don't come to my court anymore. Then I ask my usher to carry you away from my court. It is contrary to my ethics, and it is contrary to the code of conduct. And therefore, that one will amount to misbehavior. So you can get several examples depending on the facts in issue. Thank you.
Thank you very much, Honorable Minority Leader. That brings us to the end of vetting of the Honorable Nominee. May I proceed to acknowledge the guest of the nominee. First on my list is Mrs. Agnes Akosua Edrujemfi Adjei. I believe that's the spouse of the nominee. Then we have Reverend Father Andrews Campbell. We have Bafo Adjei Fosu Chuchikwa II, Asantehini Anantahini Anantahini. Then we have Nana Kwesi Oko II, Manso Tetremhini. Then we have Obrimpom Hima Dechi, Paramount Chief of Upper Discourse and Overlord of Discourse. We have Nana Asamoah Tia II, Mpatum Hini. We have Mr. Joseph William Baini, Professor Rose Emma Mama Entua Mensa. We have Samuel Ado Otu Esquire. We have Justice Eric Che Bafo, Justice of the Court of Appeal. We have Justice Efia Sawa Asariboche, Justice of the Court of Appeal. We have Justice Charles Edward Eko Bedi, Justice of the Court of Appeal. We have Justice Christopher Acha, Justice of the Court of Appeal. We have Justice Kizita Kowa Kwashi, Justice of the High Court. We have Majib Rahman Ahmed Esquire. Mujib, very well. We have Mrs. Felicia Dapa Ajiman, Chief Director, Office of the Head of the Local Government Service. On behalf, very well. We have Kwame Wiafi Adjei Esquire. Then we have Ms. Veronica Yebua, Mrs. Bridget Buachi Ampedu Esquire, Bafo Asari Krantin Esquire, and the Chief Justice and other justices of the Supreme Court that have welcomed you and thank you for coming. Honorable nominee, we thank you very much for attending upon the committee and answering questions. You are discharged, but you will hear from the committee.
Thank you very much.
Thank you very much. Our next nominee should take the chair. Honourable members, our guests, the meeting is called to order. May you kindly be seated. Standing on the existing prayers and the introduction, and by the letter of appointment of justices of the Supreme Court, we have in succession the third nominee in the person of Justice Gbiel Suurbaareh. You are welcome.
Thank you, Honorable Chair.
May I humbly give you the opportunity to tell us briefly about your background. Please, in 2 minutes.
Honorable Chair, I was born on 11th January.
Please, hold it.
I, Justice Gbiel Suurbaareh, do in the name of the Almighty God swear
that the evidence I shall give before this committee,
that the evidence I shall give before this committee,
touching the matter in issue, shall be the truth,
shall be the truth,
the whole truth,
and
nothing but the truth.
nothing but the truth.
So help me God.
So help me God.
So you can now proceed to tell us your background in 2 minutes.
Honorable Chair, I was born on 11th January 1958 in a village called Manware near Nadoli. At the age of 6, I went to Moiri Primary School, and in P6, I wrote an entry exam into St. Francis Xavier Minor Seminary, where I pursued 1 year preparatory. After that, I started my secondary education, completing the O-levels in 1976. From when I obtained my O-levels, I proceeded to Navrungo Secondary School to pursue my A-levels and completed in 1978. After obtaining my A-levels, I proceeded to Legon, where I read LLB and obtained my LLB in 1984. I was called to the bar. On being called to the bar, I was sent to Tamale to do a 2-year national service with the then public tribunals. After my 2-year national service with the public tribunals, I was appointed to work with the public tribunals, and from 1986 to 1990 in Tamale. And whilst in Tamale, I handled the public tribunals in Bolgatanga, the Upper East region, and Wa, in the Upper West region. In 1990, I was transferred to Sunyani as the regional chairman of the public tribunal until the return to constitutional rule, where I was absorbed into the judicial system and posted in 1994 to Obuasi as a community tribunal chairman. Whilst in Obuasi, I was handling the community tribunals at Hontado, Bekwai, and New Edibiasi. In 2000, I was elevated, I was promoted to the Circuit Court.
Chairman, we have the CV, so.
Thank you very much. The 2 minutes is over. Without any hesitation, I proceed to give the floor to Honorable John Dako, based on the agreed rules, to ask one question.
Thank you very much, Mr. Chairman. My love and respect, I have perused a lot of Court of Appeal judgments I've read are unanimous. And so I want to find out from you, do you think that it would be fair for anybody to refer to the Court of Appeal as a unanimous FC?
Honorable Chair, and again a case for judgment. A judgment conference is held where as to whether the appeal should be allowed or should be upheld or should be set aside. And where we agree that the judgment should be upheld and it is a unanimous decision, then one of you will write the judgment. Where one of us disagrees with the judgment, then you have to write a dissenting decision. But the fact that a decision of a court is unanimous is not anything derogatory.
Thank you very much. Any follow-up?
And so, my Lord, with respect, you will not agree that calling a court unanimous FC is a good thing, would you?
Honorable Chair, as I indicated, the fact that a decision of a court is unanimous is not a derogatory term.
Yes.
Thank you, Honorable Chair.
Thank you. I then proceed to give the floor to Yes, Honorable Tampuli, you have the floor. The same rules.
Thank you, Mr. Chair. Mr. Chairman, I would crave your indulgence to vary this one a little. I have noticed something on page 2 of the document that was given to us in respect of Justice Suurbaareh's CV, the BNI report. And if you permit me, I will just read bullet point 6 for clarification.
You have to ask question. You can choose wherever the question would come from.
It's just for the records. This is just for the records. So I just
the rule is that you have to ask one question. You may choose where the question is supposed to come from. So if you want to base the question on his CV, please do so.
My Lord, good evening and you are welcome. And I congratulate you on your nomination. I want us to take a deep dive into the Constitution. And I want us to go to Article 1273. My Lord, do you have a copy? Very well, my Lord. Article 1273. And it reads, Mr. Chairman, with your permission, a justice of a superior court or any person exercising judicial power shall not be like judicial power. End quote. My Lord, do you, in your practice, envisage a situation where this strong shield can be penetrated? Is there any occasion that you think that this ironclad shield can be penetrated?
Yes, my Lord, you have the floor.
Honorable Chair, from the reading of the provision where a Superior Court judge has given a decision in the exercise of his judicial power I don't think that the person can be subjected to any sanctions, because if you make a mistake, the other party has the right to appeal. Thank you, Honorable Chair.
Any follow-up?
Thank you. So, at the High Courts or at the Court of Appeal, you can appeal. But if you are at the Supreme Court, what remedies are available beyond review?
Honorable Chair, if you have given a decision at the Supreme Court and the person is not where you are able to establish that they are exceptional, satisfied with the decision of the Supreme Court. Honorable Chair.
I'll proceed to give the floor to Honorable Uwabafo.
Congratulations, my lord.
Chair.
At the Supreme Court, you'll be doing interpretation. And so I want to take you through a little exercise. Let's look at Article 1284 of the 1992 Constitution, which talks about appointment. It reads as follows. A person shall not be qualified for appointment as a justice of the Supreme Court unless he is of high moral character and proven integrity, and is of not less than 15 years standing as a lawyer. You will observe that competence is not a factor for appointment to the Supreme Court. Do you think it is an anomaly? And if so, why?
Honorable Chair, the fact that the provision does not contain the word competent doesn't mean that the competence of any person applying to become a justice of the Supreme Court should not be taken into account, because the person is going to be dealing with interpretation of the laws and so many other jurisdictions that are conferred by the Constitution, and the person must be knowledgeable in the law to be able to qualify as a person for the Supreme Court. Honorable Chair, that is my answer.
Any follow-up? Please do.
And so, if the appointment of a person is being challenged on the basis that the person is not competent, would you, on the basis of Article 1284, say that it is not a requirement on the test, and so that appointment will not be unconstitutional on the test?
Honorable Chair, what I said is that the fact that the word competence has not been used in that provision doesn't mean that the competence in the sense of being qualified enough to do the job should not be taken into consideration. So that because you are going to apply the law, and you must be knowledgeable in the law before you can apply it. Thank you, Honorable Chair.
Thank you very much. I proceed to give the floor to Honorable Anthony Mia. Please, you have the floor. 3 questions.
Thank you, Mr. Chairman. Congratulations, my Lord, on your nomination. My Lord, I would like us to look at Article 127 of the Constitution together with 179. The combined effect of 127, 127, 2, 3, 4, and 5, as well as Article 179(4). Basically, it talks about protection of the rule of law, particularly independence of the judiciary.
and zooms in. This is where my concern is. On the, let's zoom in on the 179, particularly 4, says that the expenditure of the judiciary as presented by the President to Parliament should not be reviewed or varied. I'm a member of the Judiciary Committee, and I'm aware that from time immemorial, budget for the judiciary has been varied, not that of the judicial service. My question is, or I seek your view on the combined effect of this. What would you suggest as some of the possible solutions to curb this? Because your brother, Dennis Adjei, JA, just left the seat, and he complained bitterly about insufficient funds for the judiciary to do what is expected. So I want you to give this committee some solutions to curb this problem so that in future there would be no constitutional violation on the part of the executive. The budget of the judiciary would not be cut, then the judiciary can use the money they need for what they have to do to ensure the independence of the judiciary. Thank you very much.
Honorable Chair, it is true that the judiciary does not have financial independence because it doesn't get all the required funds to be able to carry out its activities. I have been a supervising judge in the eastern region, the northern region, and also in the central region. And you cannot do your job effectively unless funds are available. But the problem is that and so whatever that the judiciary will be given will depend on what is available for the sharing to the other arms of government. Thank you, Honorable Chair.
Any further question?
Yes, I have a follow-up question to this. Would you recommend an action or a writ at the Supreme Court for a proper interpretation of these constitutional provisions to ensure that in future the budget of the judiciary is not slashed?
Honorable Chair, I don't think that it is that easy because, as I indicated, it is the availability, the size of the judiciary should be given so much, and there is not enough in the national pot. How can you compel them to be given that sum that you have got from the court? Thank you, Honorable Chair.
Now, can we look at your CV? Under employment history, that is 4, III. Between the year 2000 and 2004, you were with the Judicial Service of Ghana as a circuit court judge. Between the same period, 2000 and 2004, under 5, you also served as Circuit Tribunal Chairman in Koforidua. Can you clarify this?
Honorable Chair, following the return to constitutional rule, I was appointed the Community Tribunal Chairman in 1994. And in 2000, I was promoted to the Circuit Court and then sent to the Circuit Tribunal, which was dealing with only criminal cases. In 2002, made a Circuit Court judge where I was dealing with civil and criminal cases simultaneously. Thank you, Honorable Chair.
Now, my last question. I see judicial appointments to the Supreme Court.
Honorable Chair, as the law stands now, it is very clear as to who has to appoint justices to the Supreme Court. And I'm aware there is a committee that is looking at a review committee, and if in that wisdom they recommend it and the people of Ghana accept that there should be a commission. Thank you, Honorable Chair.
So this would be my last follow-up. In your view, does the appointment of judges to the Supreme Court not interfere with the independence of the judiciary, particularly at the apex court?
Honorable Chair, I do not think so, because when you are appointed as a judge, not only at the Supreme Court, you take a judicial oath, and your duty is to administer justice impartially and with the law as your guide. So the fact that you have been appointed by one administration doesn't mean that you must do away with your judicial oath and give judgments that should please the appointing authority, because you are bound by your judicial oath and to apply the law and be guided by the Constitution. Thank you, Honorable Chair.
Our members, is now the turn of Honorable Adjei Ladi Ayamba.
Thank you, Chairman. Congratulations, my brother. Mr. Chairman, I wish to find out from my brother, and I refer to him as my brother because we come from the same northern sector, and we know the difficulties that we have when it comes to our courts. Many of the districts are combined, and it is like regional level. So most of our cases get stuck. What is your suggestion or your view on us having the courts that are already built and not opened for them to be opened, those that have been opened for us to have judges in at least all our districts, and not relying on one judge to run a region or whatever? What will be your suggestion on that? Thank you.
Honorable Chair, the lack of courts in certain parts of the country, including the northern sector, is a cause of concern. And this stems from the fact that judges are reluctant to accept postings to certain rural areas because they don't have a lot of exposure from lawyers. So they feel that if they are in the rural area with no lawyer coming before them, or very few lawyers coming before them, and very few cases that are coming before the court, and they are there for some time, and they are transferred to other places which are very busy, and where many lawyers appear, they find that they are in a different world. So that accounts for many people, most of the courts in the rural areas not being manned. But I think that the judiciary or the administration should ensure that in places where we have courts, people should be made to go and occupy those courts. Apart from the Volta region and the Western region, I have worked in all other regions in Ghana. And I think that the experience I have gained in the various regions has gone a long way to influence the way I decide cases. Thank you, Honorable Chair.
When the opportunity arises, that individuals from these regions, especially the northern sector, who are interested in studying and becoming lawyers, should be given that opportunity by being given scholarships, supported, anything at all, but to be made to sign and for them to understand that when they have graduated, they must go back and serve their regions. Will you make that suggestion?
Honorable Chair, I will not subscribe to such a policy because the legal profession is a very expensive one. And when people have studied law and they are even made to sign bond to go and serve in the particular area, and the place is not attractive to them, they may be prepared to breach the bond and pay the penalty, or after they have served the bond, they can leave, and that will not help us. It is to encourage judges to accept postings to wherever they are sent to by the service. Thank you, Honorable Chair.
Chairman, thank you. I'm done.
Thank you very much. I'll give the floor to Honorable Patrick Yaboma.
Thank you very much, Conrad. That you've done quite a lot of work on the bench. And you'll be joining the likes of Justice Emmanuel Yoni Kulendi, and if God willing, your sister Hafsatu Amaleboba, also from the Upper West, will be joining. You have great lawyers from the Upper West, including our Speaker, Tadiosori, Kizito Beyu, Balori, Clement Lady, and the likes. I want to find out from you, my Lord. What will you say has been your source of motivation, and what would you do to assist the youth in the Upper West region to take keen interest in legal education, having come thus far? Thank you.
Honorable Chair, we have, or some of us have been encouraging the young people to take up legal education. But the problem has been the financial aspect. As I indicated earlier, it is very difficult. It costs a lot to get legal education. And having this regard to the distance from which most of the people will have to travel, getting accommodation. So this, even though people are being encouraged to pursue legal education, this is limited by the available resources. As one of the honorable members said, some of the conditions have been an impediment to people obtaining legal education or even further education. Thank you, Honorable Chair.
Yes, Honorable.
I think having come thus far to assist some of the youth in the Upper West region to take up legal education, your own personal contribution,
Honorable Chair, at the universities, sometimes giving some of them financial support or even making books available to them. I also have, any time that judgments of the Supreme Court are published, I forward, and I get copies, I forward it to them to keep them abreast with the latest rulings from the Supreme Court. This is the way I have been.
Question, Chairman. My Lord, what has been the most difficult decision from your tribunal days to your High Court days, your Court of Appeal days? I know it's a very difficult job, a lonely one as such. And sitting as a judge, what has been some of the most difficult decisions that you've taken? Thank you.
Honorable Chair, look at the evidence that is available, apply the law, and then come to a conclusion based on my appreciation of the evidence and the law. And I haven't come across any difficult case that was had about appeal judge case, about 6 volumes, so many maps. And that was, I think, one of the cases that I considered. We had to put stones and even sometimes use a magnifying glass to be able, because this was a very old case. The judgment was given in 1984 and then came on appeal sometime in 2022. That was, I can say that was the difficult case I ever had. But all other cases, you need to study them well and then come out with what you feel is the correct position based on the evidence and the law. Thank you, Honorable Chair.
So, as a judge, when in difficulty, are you with some understanding when you are locked up one way or the other?
Honorable Chair, confer with others to assist you come to a decision on a matter. I even refer matters to some lawyers, do research for me, or law students do research for me in this area because I'm very busy. And they do the research, give me the report, and then I also look at it with whatever that I have, and I come to a decision based on the assistance that's given me by either my colleagues or the people in academia. Thank you, Honorable Chair.
John, my last question. My Lord, on your CV, page 1, marital status, single. Number of children, 2. And on, my colleagues want to be mischievous, don't mind them. And hobbies, observing nature. My Lord, what kind of observation and nature observation, given the fact that you are single with 2 kids and you love to observe nature?
Honorable Chair, I think I will take the opportunity to make a correction with regard to my marital status. I was married and had 2 children. Unfortunately, my wife died. Then I decided
Condolences, my Lord.
I decided to marry, not single. Observing nature, sometimes when I read and I'm tired, I just walk around the garden or walk around and observe nature, because that's the only thing. I don't have much society life.
There are a lot of will-be applicants here, so don't worry.
Honorable Patrick Yawoma, is that eligibility criteria?
Mr. Chairman, Honorable Akurugo has been smiling, and I don't know, my Lord. You can't tell anything, my Lord.
I will give the floor to Honorable Umar.
Thank you, Chairman. Congratulations, my Lord. I have a very simple, but it looks difficult question. And this one, till 2020, citizenship in Ghana was strongly held by producing birth certificate. But in 2020, when the Electoral Commission wanted to do the new register, citizenship was redefined to say that birth certificate was part. As a politician and public servant, I have several people who give birth to children in town, in the country, who were born in the 70s. And yet when they go to register national ID, they are told that they are not. What other documents do we need to prove? Where some countries use citizenship by descent or citizenship by birth. Where do we
What is Alhaji Umar, Honorable? What then is your question?
My question is, what documents can we review that? What documents do we need to prove as a citizen? Thank you.
Thank you very much. My Lord, you have the floor.
Honorable Chair, one will have to look at the Citizenship Act, what it says. But I'm also aware that the Supreme Court has made a pronouncement with regard to the birth certificate. And that being the case, the position of the Supreme Court until it is reviewed remains the position of the law, and one has to go by it. Thank you, Honorable Chair.
I wish you well.
All right. Thank you very much, Honorable. Yeah, Akoko, you have the floor.
My Lord, congratulations.
Honorable Chair.
Yes. The old boys of Xavier Parliament. You are ascending to the very apex. That is the spirit of you. We wish you well. Xavier will be.
Thank you, Honorable Chair.
Honorable, you have the floor. And please, let's go straight to the question.
Thank you very much, Mr. Chairman. And my Lord, congratulations to you. Indeed, we are very proud of you, Justice Kulendi. So we now have two justices from the Upper West region in the Supreme Court. And so, he will go through. And the third one is still on the way coming. So we are going to have, eventually we are going to have three. And I think, yes, we had nothing in the past, so we have to catch up. So we are happy that you are coming through. You served as chairman of the public tribunal under the PNDC. The 1992 Constitution provides under Article 142 the establishment of regional tribunals. Since 1992, no regional tribunal has actually operated in this country. At least that's what I know. The current Attorney General is making a strong case for the establishment and operationalization of the publicly. You worked under the public tribunal system. 142, whatever it is. Yeah. 142. What did I say? 142, 143. What did I say?
Please proceed to us.
You worked under the public tribunal system, and then you also worked as a high court judge under the traditional court system. So you have had the opportunity of the two systems, and you have the experience. Now, my Lord, what is your opinion about the operation of the public tribunals system? Do you think that will help the justice system of this country? Thank you.
Thank you very much. My Lord, before coming to provide answers to the question, let me place it on record that as young lawyer, in the early days of 2002, 2003, I have appeared before a regional tribunal at the beach side in Accra. So it couldn't be true that from 1992, regional tribunals did not operate. You may then proceed to answer the rest of the questions.
Honorable Chair, I think the inclusion of the regional tribunals as part of the Superior Courts in the 1992 Constitution was not an accident. It was based on the experience and the negotiations that took place, resulting in the promulgation of the 1992 Constitution. I'm aware that they were operational, but for some time now, the regional tribunals have not been operational. And if there is a need for them to become operational, I do not see anything wrong with the cases, especially corruption-related offenses, narcotics, and other serious crimes that affect the state by the regional tribunals, who will not be dealing with civil cases and this of cases. And I think the inclusion of the regional tribunals was as a result of the successes that were chalked by the erstwhile public tribunals in bringing corruption to a minimum during the PNDC era. So I have no problem if the regional tribunals become operational. Thank you, Honorable Chair.
Thank you, my Lord. Any further question?
Thank you very much, Mr. Chairman. I'm fully satisfied with that answer. And so I will proceed to my second question.
Please do.
My Lord, this matter has come up, but let me pick your mind on it. Should there be a cap to the number of Supreme Court judges? And if so, where should it be capped? Thank you.
Honorable Chair, I do not think that the Supreme Court should be capped. If you look at the jurisdiction of the Supreme Court, it's not going to be helpful. So I think the open-ended way it is will give the appointment needed at any point in time. But I believe that the appointing authority will use that power reasonably and will not one day get up and appoint 100, 20, or 30 Supreme Court judges. Thank you, Honorable Chair.
Any further question?
Well, no.
There cannot be exception to no further question. I'll proceed to give the floor to Honorable Jerry Ahmed Shaib.
Mr. Chair, thank you very much. Honorable Nominee, congratulations, you're welcome.
Chair.
So, Honorable Nominee, I heard you and I read from your CV. In fact, I read from your CV about your hobby, which is the observation of nature, and you're about 66 years. Is that correct? 67, very well. Chair. And so, at 67, you observe nature by walking in your garden. And it's not the Garden of Eden. I'm just trying to find out, whilst observing nature, has anybody, as a party, an interested party in a matter, offered you bribe?
Honorable Chair, I don't remember being offered a bribe by anybody.
Which is, so I'm asking this because I want to find out, if, assuming without admitting, which obviously you have said that nobody has offered, if somebody offers you a bribe, what would be your step? What would you do?
Honorable Chair, I indicated that I don't have a social life. It is either reading, and then sometimes I attend funerals when it's very close to me. And so, and by my Catholic upbringing, it will be against my conscience to accept a bribe so as to influence me in the decision that I'm going to do. Because I am bound by my judicial oath to give judgment based on the evidence and the application of the law. So I will not allow any monetary influence or any other gift to influence the decision that I'm going to take. Thank you, Honorable Chair.
Very well, thank you very much. If you met the Constitutional Review team now, what would be your recommendations for them to consider? If you can give me about 3 of them, I would appreciate that.
Honorable Chair, what immediately comes to mind is the appointment of majority of members from Parliament by the President, of ministers from Parliament, because I think that if we take a second look at that provision, it will enhance the quality of debate in Parliament. I'm also of the view that with regard to the removal of a Superior Court judge or a chairman of a regional tribunal, it should the same procedure that will apply in the removal of the Chief Justice should be applicable to Superior Court judges and regional tribunal. These are the only 2 I have in mind. Thank you, Honorable Chair.
Would you not, as part of the ones you have in mind, consider the extension of retirement ages for Supreme Court judges, maybe to 75, because... Oh, this is a follow-up.
Answer the question.
Honorable Chair, I started working at the age of 26, and I've done about 41 years working. And I think at some point in time, I need time to rest. I do not want to work until I fall. dead. So I'll need some time to rest and relax. So I do not think that extending the time beyond 70 years will be beneficial to me. I do not know the views of others, but I think the 70 years is okay, so that the person who has worked there to marry, when I married the second time, I had this case I was talking about. I unfortunately asked for permission to stay in the visitor's room to enable me concentrate on the job. And I think that was one of the problems that ended the marriage. Because the woman will come down every 5 minutes to check out whether
Thank you very much. Yes, your last question.
Thank you very much, Honorable Chair. Some politicians have made pronouncements on the composition or the constitution of the Supreme Court, the bench. And judges, Supreme Court judges largely have been denigrated, decorated, or described in several ways and forms. With your nomination, what would you say about such descriptions?
Honorable Chair, I believe that such descriptions are based on the fact that the public or most people do not know what goes into making decisions. Issues and the facts and the circumstances of each case will determine the decision that the court will come out with. And if after discussions, the panel think that this is, or the majority think this way, they give the decision, that is the decision of the court. If for one reason all the judges agree that has the right to go further upstairs, even in the case of the Supreme Court, as I indicated earlier,
So by your answer, we can say clearly that there is no unanimous FC, there is no MPP bench or NDC bench. That is correct.
Honorable Chair.
Well, that question has been asked and answered, so it couldn't be. There was a question that the Supreme Court is being referred to as a unanimous FC, and he has explained clearly.
I still have a follow-up. Thank you. So, Honorable Nominee, is it the case that decisions that are made at the Supreme Court are made just because judges who have been empaneled have dealt with the matter and they have come to a conclusion that this is the way to go and not because they are following any partisan lines? Is that the case?
Honorable Chair, as I indicated earlier, any judge is bound by his judicial oath, and his allegiance or his or her allegiance is to the law. And so you do not look over your. It's clear that you have arrived at the right decision. As for whatever people say, that is besides the point. Thank you, Honorable Chair.
Thank you. I'll proceed to give the floor to Honorable Roxanne Nelson Kwame Adjei Dafamoko.
My Lord Suurbaareh, JA, JS is soon to be for your nomination. I have no question for you. Safe to commend you as one of the judges who took interest in my formative years at the bar. Always reported on my performance in court to my pupil master. And I like you for that, because you, even though you were a judge, you were interested in lawyers doing well who appeared before you. And I'm grateful for that guidance and tutelage. and I know that you still do it to other lawyers who appear before you. You've been 38 years on the bench, from 1987 to now. Yes, I'll conclude, Mr. Chairman, I'll conclude. You see, we don't get the opportunity to commend the industry that justices like Suurbaareh put in their work on the bench. And I believe that this is a platform for me to do so for the nation to hear. You deserve to be appointed onto the Supreme Court. And I wish you well for the rest of the period that you spend until you turn 70. I wish you so well, my Lord. Chairman, thank you very much.
Thank you too. Yes, Honorable Majority Leader. Very well. Then I will then move to Honorable Patricia Adjei, Deputy Ranking.
Thank you very much. We have discussed at length over here by previous nominees on the issue of judiciary corruption and the public trust. It's actually a perception that must be dealt with. But what I would like expose led to the suspension of 22 circuit judges and 12 high court judges. What greater role should the Supreme Court play in rooting out corruption within the judiciary? Honorable Dominic, if I may ask that.
Honorable Chair, the judiciary is a human institution, and it will not lack its badness, overhyped. I also want to draw the attention of the public to the fact that people tend to confuse the judiciary with the judicial service. The judiciary are the judges and the magistrates who adjudicate on cases, while the judicial service comprises of directors and other staff that assist the judges to take decisions. We all wear black suits, and people are not able to distinguish corruption or misconduct by the judiciary together without distinguishing between judges and judicial service staff. Thank you, Honorable Chair.
Thank you. Following from my initial introductory or reference to Anna's expose, may I know, do you support undercover investigations to expose misconduct among judges? And what ethical issues will arise out of that? Thank you.
Honorable Chair, so the protection of individual rights. So I would think that it's a matter of how we balance the two. Thank you, Honorable Chair.
Going by your statement that corruption has been overhyped, and looking at how issues of addressing corruption, may I ask, should Supreme Court judges or justices be required to publicly disclose their assets annually, or would such requirement violate judicial independence?
Honorable Chair, I am aware that judges are required to declare our assets periodically. And I remember before I left Kumasi last year, I declared my assets and I left it with the audit service before I was transferred back to Accra in November 2024. Thank you, Honorable Chair.
I have one other interesting balancing question. How do you balance respect for local cultural norms against international human rights obligations, if referencing anti-LGBTQ? Yeah, thank you.
Honorable Chair, I'm aware that the Supreme Court has made pronouncement in respect of this issue, and that also a decision has been given as to whether the offense of unnatural carnal knowledge is inconsistent with the Constitution. And I believe that these decisions of the Supreme Court reflect the views of our society with regard.
Honorable Nominee, one other interesting question that I would like to introduce here is on conflict of interest and personal affiliations. May I know whether your current membership in a particular organization, religious values, and other businesses can compromise your impartiality in the delivery of your justice? Thank you.
Honorable Chair, I don't see how my belonging to an organization or being a member of a religious group should affect my judicial oath in administering justice impartially without fear or favor, because by my judicial oath, I owe allegiance to the law and the Constitution. Thank you, Honorable Chair.
And my last question, I never missed that one. I don't know, for some reason, I thought I came through your CV. You are one of the people that established the gender desk for the Judiciary or something. I don't know, I came by it. I thought, no, maybe not. But may I tease out your view? Who have reached the status of being in the judicial effort to achieve that in the Judiciary. Thank you.
Honorable Chair, I think the Judiciary is doing very well as long as gender parity is concerned, because I believe that currently more than half of the population of judges and magistrates are females. But I believe that gender equality should not be used in a blanket way to appoint women to positions just to attain gender equality. We should look at the competence of the person when it comes to appointment, and so that you should not appoint a woman just because you want to achieve what the gender activists are looking for, but the person should be qualified for the position that she's being appointed to. Thank you, Honorable Chair.
Thank you very much, but I'll do a follow-up, Mr. Chair. My question is how we can achieve that. I equally agree with you that we can't just promote people for the sake of achieving parity. But you know, in the judiciary, or you know in the service where we are and how we can facilitate the process of men out to me. I want your views on that, because then I believe there should be a special effort to do that, because we've passed the law because we believe women are vulnerable in that sense, and there should be a way of achieving that. And that's one of the reasons why I ask these questions. I want you, in your own thinking, how can we facilitate that, the achievement of that parity issue? Thank you.
Honorable Chair, this can be achieved if the women work hard to qualify for the positions that they are looking for, which, as I indicated, you just don't appoint a woman to a position because you want to attain gender parity. Thank you, Honorable Chair.
I don't want to belabor that, but maybe because you are indicating by your statement that we don't work hard enough. You are not looking at, no, yes. That's how I feel about it, because it's not because of that. You know that we have some patriarchal issues that have contributed to all these things. And therefore, we must be looking deep into the way we do things to ensure that we can encourage and promote the interests of the women as well. Thank you. Anyway, I don't have any more questions for you. I wish you the best.
Thank you very much. I now give the floor to Honorable Kweku Riket-Hagan, the Vice. Very well, very well. Now, Honorable Togbi Osahin Alexander Kwamina Makin. Afanyo Makin, you have the floor.
Lord, please, do you have your LLB certificate with you here?
Honorable Chair, I do.
Chairman, with your leave, I would want to peruse a copy.
Very well. But you can proceed with your next question as they bring a copy.
Honorable Nominee, are you able to confirm for the records where you had your national service?
Chair, I was attached to the then public tribunals for national service for a period of 2 years, because at that time, that was the number of years one had to do national service. And I did it in Tamale, in the northern region. Thank you, Honorable Chair.
Chairman, what the nominee has given us is yes, I'm talking about, this is your professional certificate, your call to the bar.
The degree.
The one from Legon. Yes, please.
Well, he wants to peruse it, so I don't know why. So once it's available, send it back to me.
No, we don't. That one is not in doubt. Yes. Chairman, that is enough. We've seen it. The reason I needed to validate it was because as part of the due diligence, Legon wrote that they don't have you on their record. That is why I wanted to be sure of this so that the matter is settled. So it's in your own interest. Pardon? I have seen, no, it's part of the document we have. I've seen the seal of Legon, so I have no doubt. I'm not in doubt of what you provided, but I needed to, clear this because of the information that came from them, to us. Thank you very much. Honorable nominee, you've tendered your tax. You've tendered your tax of yours, whether you did that yourself. The purpose is to satisfy the requirement of Parliament to support nomination to position of Justice of the Supreme Court.
Honorable Chair, upon being requested to submit a tax certificate, I called the Human Resource Department and I was directed to an officer, and later on I was given a copy of the tax certificate. Thank you, Honorable Chair.
If you say a Human Resource Department...
Honorable Chair, that is exactly so.
And the HR referred you to an officer within the HR or different department?
Honorable Chair, an officer within the Judicial Service. Thank you, Honorable Chair.
All right. So what did this officer do? The person they referred you to, what did he do?
Honorable Chair, I have no idea what he did, but I believe that he would have looked at my pay slip and the deductions that have been made over the years in coming out of it. But I business apart since I completed school, and I've been working with the Judicial Service. Thank you, Honorable Chair.
So you didn't sign any document prior to receiving this certificate?
Honorable Chair, I believe that when they brought it to me, when they completed, it was brought to me and assigned before submitting it. Thank you, Honorable Chair.
No, you said you believe that you signed.
I have a copy. I can check to find out whether I signed or not.
Please.
But I think I did.
Okay, you have it with you here?
Honorable Chair, I'll check up and see if it's among the documents.
Very well. You may.
There's no business. No. Honorable Chair, I've looked at it and there's no column for me to sign.
Chairman, with your leave, may the nominee share the tax computation document with us. I'm quite curious because we all undertake this exercise and there's a column for us to sign. So if you can make available the particular document. Honorable nominee, what you just brought is a certificate itself, the final document you get, which is called tax clearance certificate. If you will bear with me, my question to you, what work he did he bring it to you? Did he bring you a set of documents for you to peruse and to sign before taking them to the GRA, to the best of your knowledge?
Honorable Chair, I was given this certificate, which I submitted to the committee.
So, he is an...
I think I've already indicated that the officer was somebody within the judicial service.
Right. My lord, we are dealing with the law here. Unfortunately, you are a judge. I am probing this because if the officer were to be an independent consultant, a tax advisor to you, the mandate would have been given by you for him to sign those declarations on your behalf and proceed to GRA. But if the person is a judicial service staff, unless you give a written authorization for him to sign on your behalf, it becomes, and be very specific, because if you didn't sign the forms, how could he have sent it to GRA for the purpose of obtaining tax certificate on your behalf and in your name?
Honorable Chair.
Honorable, my Lord Justice, we have the chairman of the GRA here. The question that he's asking, we've all been going through it. I think we've done it severally. We draw our salary from Parliament. If you don't have an additional income to disclose, you depend on the account section to do the computation for you. It's taken to GRA, and GRA will then issue you the certificate. That is the procedure involved. Unless you have income other than the one that you take, the accounts department will do the computation for you. That is what we've all been going through. So, GRA board chair, you have the floor.
Thank you very much, Mr. Chairman. Precisely so. I mean, if you don't have any income other than the one that you get, say you're a member of Parliament, the computation will be done. I mean, wherever it requires that you have to sign, GRA cannot give you a clearance if that has not been done. So if he's holding a clearance, then that's compliance.
Chairman, I've been exercising patience to manage this process, and I'll continue to exercise that patience. You and your vice chair haven't gotten to understand my question. The nominee says he was asked to see an officer, and after seeing the officer later brought him this tax clearance certificate. Now, the computation, be it an account officer in your own office or whatever, after he or she is done with the computation, he brings a form to you to sign. It's a declaration. Then he or she will take it to GRA. Unless the board chairman here is saying to us that whoever is the accounts officer or the tax expert, if he fills the form, there is no such requirement for you to sign. If that is so, let it be on record.
But, Honorable Minority Leader, is the certificate in issue? Do you have a doubt about the certificate issued by GRA? If you have a doubt, say so. Because official documents are presumed to be correct unless you establish to the contrary. I'm not a judge anyway. The GRA certificate is an official document, and it must be presumed to be correct unless you establish to the contrary. So if you don't have a doubt about the document that has been produced, then the presumption of official document applies. The regularity of official documents applies.
Man, this certificate is a sign of compliance, period. Okay.
Honorable Chairman and colleagues of this committee, let us be careful with the precedents we are setting. I always keep quiet for you to make your point. So please, extend the same courtesy. It is not the regularity of the certificate that is in question. I am talking about the processes leading to the issuance of the certificate. Obviously, if anybody takes a declaration form computing your tax obligation to GRA with a signature, it will be presumed to be regular and this certificate will be issued. I am not attacking the certificate. I asked a very simple question, which you gave an honest answer, that this officer, that the HR department, not going to GRA, did he come to you to sign the declaration before proceeding? If he did, yes. If he did not, we move on.
Honorable Chair, to be frank, this was the first time that I was ever asked to produce a tax clearance certificate. And because I didn't know what from the government, I decided to seek the advice of the Human Resource Department. And he told me that an officer in the Accounts Department will work on it. But I cannot remember if before sending whatever they did to obtain this certificate, whether they brought any document for me to sign. I cannot recall it because that week I believe I was sitting. And I was also interviewing. The document was brought to me by the officer from the Accounts Department who was working on it. Thank you, Honorable Chair.
Would you check with this officer, since you don't remember, and update the committee accordingly? Is that okay?
Honorable Chair, I don't even remember the name of the officer.
Honorable Nominee, since you don't remember the name of the officer, but remember the HR department, the HR officer who directed you to see this officer, would you cross-check and update this committee on what actually went into the source document that went to GRA?
Honorable Chair, if the committee so decides, I can do that.
We can make progress. Honorable Nominee, I want us to address the issue of compensation of victims of miscarriage of justice under Article 14(7). A person who has served the whole or a part of a sentence is acquitted on appeal by a court other than the Supreme Court. The court may certify to the Supreme Court that the person acquitted be paid compensation, and the Supreme Court may, upon examination, as it may think fit, or where the acquittal is by the Supreme Court, it may order compensation to be paid to the person acquitted, end quote. Now, recently, the Court of Appeal overturned the conviction of a man who has spent 23 years in prison for his alleged involvement in armed robbery cases attributed to the notorious Adjei. Similar cases of long-term incarceration followed by acquittal have emerged also in recent years. Now, question to you. In the light of these developments, what key principles or factors, in your view, should guide the award of compensation to persons who have suffered miscarriages of justice under Article 14(7).
Honorable Chair, from the provisions that you just read, the Supreme Court uses compensation to be awarded. And I believe that the Supreme Court judges, of their experience of the law and experience in education, will take all the necessary factors into consideration in deciding whether it is an appropriate case to award compensation or not. What I will want to add is that if the person, assuming that the court acquits the person after he has served part of his sentence or the whole of part and fails to recommend to the Supreme Court, I believe that the person can make an application to the Supreme Court or take an action to seek to claim compensation for the period that was spent in custody. Thank you, Honorable Chair.
Now, my Lord, clearly this provision allows for a judicial discretion. Would you, in the interest of ensuring certainty and clarity, suggest the introduction of legislative guidelines by Parliament for the purposes of regulating such awards?
Honorable Chair, that would have been the best thing to do. But since we do not have any such guidelines, we will trust in the ability, faced with such a situation, to use the best of thy experience to decide on what to do in the circumstances. Thank you, Honorable Chair.
But by way of follow-up, but you firmly hold a view that for the purpose of consistency, fairness, and transparency, an enactment to provide a clear guidelines, an enactment in the form of, let me be very clear, an act of parliament or a CI to guide the whole exercise of this discretion would be a better approach. Do I hold you to that opinion?
Honorable Chair, if there are such rules, that would be okay. But in this case, the law is that they will use that discretion. And discretionary powers are governed how a body or any institution uses discretionary powers is in Article 296. And so we have trust in the Supreme Court to use that discretion fairly in deciding whether to award compensation in any particular situation or not. Thank you, Honorable Chair.
Thank you. Honorable Nominee, now let me pick your thoughts on judicial appointment and executive influence. There is this school of thought that advocates for constitutional amendment to eliminate the present rule in the appointment of justices of the Superior Courts. Well, according to their views, an independent judicial appointment commission should be established with a mandate to receive applications, vet nominees, argue that such a framework will help insulate the judiciary from executive influence and thereby deepen judicial independence. They are not saying that there's no judicial independence, but they're saying that it will deepen judicial independence. Now, my question to you, what is your position on this proposal, particularly in the light of Ghana's constitutional framework and democratic practice.
I can say is that the system that we have is, or we recommend a change. I think we can continue to go about it. And I've indicated that the fact that a Supreme Court judge has been appointed by a particular government doesn't mean that that judge should give the decisions to favor that government, irrespective of the facts and the issue that fall for determination. Because a judge must always be guided by your oath of office and true to the law and the Constitution. Thank you, Honorable Chair.
Well, my Lord, you are also aware that sometimes in the exercise of executive power of appointment, you know, we've had concerns in the public space where some have argued that why a particular person and when not another. Perhaps their argument is founded on the principle of seniority. And it is against this backdrop that some of these proponents believe that taking the power completely away from the presidency, or the president, or the executive, and giving it to a constitutional body, a commission, which will be a judicial appointment commission, with those powers will rather give rise. Don't you think that it suffices in this direction?
Honorable Chair, who is going to appoint that body? And will the appointment of that body, will it be that body as to how it does its work? I think presently we have Council of State and the advice of the Judicial Council, and the person will have to be vetted by this honorable committee before you can be appointed. So there are sufficient checks and balances if we all live up to our expectations as citizens of this country and making sure that people that are appointed to the Supreme Court or any other level of the court are people who deserve to be there. Thank you, Honorable Chair.
Now, let's turn to Article 146 on the issue of removal of Superior Court justices. There is a school of thought that holds this view that the current process for removal of justices of the Supreme Court, as outlined in Article 146, should be replaced with a system where the disciplinary arm of a proposed Judicial Appointment Commission investigates complaints and forwards its findings to Parliament. And that under this model, Parliament should then take a final decision through a vote supported by at least 3/4 of all members of Parliament. Do you believe this proposal alternative would be better safeguard in terms of judicial independence and integrity?
Chair, any provision or improvement on what we have now will be welcome. But until we have that improvement, we have to do with what we have. Thank you, Honorable Chair.
I agree that until there is a new proposal, the law, such proposals to bring clarity are welcome. But what improve? Very well. Right. Well, thank you for that better description. that in itself concedes, means that we all concede that the current provision is problematic. Now, in looking for improvement, what would be your own views by way of how to improve this provision? What would be your considered proposals or views on this?
Honorable Chair, for such improvement, it has to be subject to debate by either the people or by Parliament. And I'm aware of the work that's going on by the Constitutional Review Committee. And if they come out that there is a need for amendment and to achieve it. Thank you, Honorable Chair.
Lord, can you do this committee a favor with your own views for consideration by the Constitutional Review Committee? Can you share just one?
Honorable Chair, I think earlier from a question from a member, I came out with two. That is the appointment of majority of ministers from Parliament, and also a suggestion that the procedure for the removal of the Chief Justice should be applicable to the removal of all Superior Court judges and the regional tribunal. As the procedure stands now, in the case of other Superior Court judges, including the Supreme Court judges, the decision of whether there's a prima facie case is taken by only the Chief Justice. Thank you, Honorable Chair.
Now, let's deal with Parliament. The issue of parliamentary quorum and voting under Article 1041. During plenary sessions, attendance often fluctuates because members go in and out. Against this background, Article 1041 of the Constitution provides, quote, "Except as otherwise provided in this Constitution, matters in Parliament shall be determined by the votes of the majority of members present and voting, with at least half of all members of Parliament present," end quote. How do you interpret the requirement of 1041, especially in terms of quorum and valid decision-making in the House? What's your own view on this?
I believe that the Constitution is very clear, and the issue of quorum will be determined on the number of parliamentarians, and what the law provides should constitute majority of those present. Thank you, Honorable Chair.
My Lord, have you had the opportunity of reading the Justice Abdullahi case?
Yeah, I have.
Without refreshing your memory, can I proceed to pick your thoughts on that judgment? If you need to refresh your memory, fine, I will stay away from it. But if you are so clear with the judgment, I may want to tease your view on aspect of it.
Honorable Chair.
Honorable members, we need to operate within the rules. This is a judgment delivered by the Supreme Court, properly constituted. Here is a nominee before us. Asking him, I do not think we are fair to the witness.
We are here conducting this exercise. We've had nominees expressing views on judgment, expressing views on judicial pronouncement. How then the nominee says he's read that judgment? I'm asking a question, the judgment, or he's going to question it. Then if you are ruling us out of order this way, then why are we here, Chairman?
Well, and he indicated that once the Supreme Court has delivered a judgment, that is the decision of the judgment.
No, please.
The word he uses, whom am I to comment on that particular decision? That was what the judge said. It's a similar thing that you are asking, my Lord, before us.
And with the greatest respect, I think that we need to situate some of these things in proper context. What my Lord Dennis Adjei said was misconstrued by you, with the greatest respect. He understood the question to mean that he having to overrule that. And then he said, oh, that is the decision of the court. Who am I? He didn't continue. And I understood that to mean that, yes, when the court has ruled, it is binding. And I went further to say that the recent Kowasefua case, I had my own disagreement. But in the spirit of that principle of yielding in obedience to a court decision, I had to even rely on the majority decision led by my Lord Kulendi to make my case on the floor of the House. I moved away from that to then ask him his view. If judges come before us and they cannot express their view on a matter, we are not saying that they should sit here and overrule. That is not what we're saying. A judgment is binding on you, but you can express a view. And don't forget that the same Dennis Adjei talked about the and/or interpretation, where he believed that a particular panel interpreted the end in a manner. And when that panel was out, a new judge, a new panel led by the all group gave a new ruling, and that was it. So please, I don't want us to be having back and forth on the matter.
So
I only ask, can I finish, Chairman? Chairman, you would say what you want to say. Please, bear with me, with respect. I am not locking up the nominee's neck in any hole. I ask, my Lord, have you read the Justice Abdullahi case, which is relevant to my question? The article I quoted, he said yes. And I said, my Lord, if you can proceed to answer questions without refreshing your memory. If he says that he would need to refresh his memory, we move. Because if the man has read and he doesn't have the judgment with him here, I cannot ask an opinion. That does not mean that I'm asking him that a judgment which is binding on him, he should come and condemn it. That is not the gravamen of the question. So please, Chairman,
well,
let's get the exercise right.
Honorable Minority Leader, we are all here. Justice Sir Dennis expressed his view on two judgments that exist to mean and, but in the latest one, all has been defined to be all. He never expressed any opinion, just like, unlike what you are asking the current nominee to do, what is his opinion on a judgment delivered by the Supreme Court. So with all due respect, any question soliciting an opinion of the nominee on a judgment delivered by the Supreme Court will be overruled.
Well, Chairman, my job here is to yield and show you respect and leave the matter to the jury out there. Honorable nominee, haven't read the justice that judgment.
Honorable Member, with all due respect, if a judgment is delivered by a Supreme Court, it means that the Supreme Court has reached a conclusion on the judgment. I don't think it is fair to be asking a nominee before us to be drawing a conclusion different from the conclusion of the Supreme Court in the matter.
Okay. Chairman.
So, with all due respect,
Chairman,
I have overruled you.
Don't worry. I am proud of my principals who trained me in my early days in practice. on how to stand firm in cross-examination. Don't worry. I will yield to you and proceed. My Lord, upon reading the Justice Abdullahi case, what did you deduce? What did you deduce out of the judgment? What were your own deductions out of the judgment?
Honorable Chair.
Well, it's a similar question that you are asking, except to say that, honorable members, vetting is not cross-examination. Because in cross-examination, you are to establish something against the witness or the accused person. You ask questions to establish the guilt or otherwise. So don't be under a mistaken of the fact that vetting is not cross-examination. The essence of vetting is for us to establish the eligibility criteria, whether the person is suitable to be appointed to the Supreme Court or not, being guided by the Constitution that set out the requirement based on which a person can be taken to the Supreme Court. So the issue is whether the person is qualified or the person is not qualified, but not to cross-examine.
Chairman, I'm not saying I'm doing cross-examination here. I said, listen, please, Chairman, please. Please. What I said, the import of what I said was that the learning on cross-examination enabled me to build resilience on how to navigate. So I'm not too worried about you are out of order on this or that. I would have my better approach to get the right question through. That's the point I was trying to make. I wasn't saying we are doing cross-examination. So, my Lord, having read the Justice Abdullahi case, judgment delivered in respect of that case. Thank you very much.
Honorable Chair, I must confess the past 3 days I have been given a number of judgments to read, which I maybe ask questions on. And I've gone through the Justice Abdullahi judgment. But before I can say anything about it, I would be grateful if you could refresh my mind about the case.
Very well. My Lord, you can readily refer, since you say you've read it, you have it with you. Ah. Oh, okay. Like you don't have the stable. So there can be another opportunity. Anyway, we make progress then. Now, let's deal with the issue of constitutionality of MP share of the District Assembly's Common Fund. My Lord, Article 2522 of the 1992 Constitution provides that, quote, you have your Constitution with you, please?
Honorable Chair, I do.
Okay, so let's go to 2522. Article 2522 of the 1992 Constitution provides, quote, Parliament shall annually make provision for the allocation of not less than 5%.
The article again. 225.
Yes. Sir. 2522, subject to the provision of this Constitution, Parliament shall. Article 252, subclause 2.
Yes.
My Lord, please, are we there together?
Yes. Yeah, I'm there.
My Lord, you agree with me that at the bench, you draw your lawyers' to ensure that they comply. You know that. You've been doing that just to make sure that. So we've learnt at your feet, and we're trying to do this exercise for the good of the country. So don't take it personal. Of Ghana, to the district assemblies for development. And the amount shall be paid into the district assemblies common fund in quarterly installments. Further, Article 2533 states, quote, monies accruing to the district assemblies in the common fund shall be distributed among all the district assemblies on the basis of a formula provided by Parliament. Well, in practice, Parliament has approved a formula that allocates portions of the common fund directly to enable members undertake certain developmental-related interventions in their constituencies. In your considered view, does this practice align with the constitutional scheme and spirit of Article 252 and 253?
Honorable Chair, I've just been taken through the Constitution, the provision. I've never had any opportunity to look at it, and I cannot offer any opinion sitting here now.
Honorable Chair, that will be the end of my questions to the nominee.
Yes, Honorable Kwaku Rega, you want to make a clarification? Please do.
Thank you very much, Mr. Chairman. I think Minority Leader made a request for documents behind a tax clearance. But I want to make it clear from the explanation I gave is that when you are preparing your tax clearance and you have someone doing it for you, auditor or an accountant, it's as if you have given you give power of attorney basically by convention to the person to do it. So you don't necessarily have to sign anything, though you are responsible for your tax clearance. But once you nominate someone to do it for you, that is like giving power of attorney. And if you go to the Judiciary to ask for the nominee's name, you will be able to find who the power of attorney was given to. And it is not upon the nominee to provide you with that information. Thank you.
Chairman, for the purposes of what the Vice Chair has just said, and you deferred to him because he chairs the JRA board. And sitting here, I heard him make certain calls to validate. Mr. Chair, with respect, I know that when you nominate a consultant to discharge those duties on your behalf, it is a mandate given to an independent tax consultant. That is different from an officer in your establishment who you assign to prepare your document for tax purposes.
It's most unfair. You can't run your own commentary.
You see,
what you are doing is against the protocol. We are done. You are running commentary.
Honorable Roxanne Nelson Adjei Dapamako, out of order.
All I am saying, I in filing my tax obligations in the office would have to sign. When, as a parliamentarian, we are filing, we go there, when the account is done, down there, the office there, they bring it to us to sign. And I'm saying...
Honorable Minority Leader, and in conclusion, please, in conclusion.
Chairman.
That's why I'm asking you
Chairman.
whether you are done.
Chairman, you see, Chairman, if you continue to encourage these things, the otherwise peaceful protocol we have all reached to proceed may degenerate.
Honorable member, what else do you expect me to do other than ruling him out of order?
Chairman,
Under the rules.
let's leave all the matters
Well, under the
to
rules,
the jury out.
what do I do apart from ruling the honorable member out of order? We are guided by rules. And what the rule expects me to do is if a member is not operating within the order, I rule the person out of order. That in any manner whatsoever. So you have no need to produce any document before the committee. Honourable members, I will proceed to acknowledge the revered guests of the nominee seated behind him. First on my list is Laura Na Powell Cabo III, President of the Laura Traditional Area and President of the Upper West Regional House of Chiefs. Sakpe Na Honorable Alabira Ibrahim, Paramount Chief of Sakpe Traditional Area and National President of the Navrongo Old Student Union. 3. Professor Na Basing Banueng Yakubu, Acting President of Yulo Traditional Area. Isaku Dapila, a Prince of the Nandoli Traditional Area. Prince Galadin Banyara, a Prince of the Nandoli Traditional Area. Bashiru Dapila, a Prince of the Nadoli Traditional Area. ACP retired Paul Kuntoma, a Prince of the Nadoli Traditional Area. Philip Bazing, PAD, a cousin and retired Municipal Coordinating Director. Ignitia Suurbaareh, daughter. Mary Magdalene Kaimabo, Gbiel, daughter. Dr. Elias Sorry, retired Director General, Ghana Health Services. Ignatius Baika Daunoba, retired Chief Director and representative of Xavier Old Students. Honorable Clement Bugasi, former MP, Navrongo Central, and representative of 1978 sixth form class, Navrongo Secondary School. Emmanuel Nuwilayuri, Divisional Chief of Kaleo Traditional Area and representative of Xavier Old Students. Thaddeus Sorry, Esquire, and representative of the Upper West Lawyers. Thomas Dakora at Tom Tom, Ekuafo Hall, mate and representative of Nabia Accra branch. Goodman Sedu, friend. Dennis Adongo, friend and parishioner of Christ the King Catholic Church, Cantonment. Vincent Suglo, a nephew. Joachim Basing, Esquire, nephew. Ernest Iraku, parishioner of Queen of Peace. I welcome all of you. Honourable members, let me also commend highly the Acting Chief Justice and other Supreme Court Justices who have been with us throughout the whole day. The first person, second person, and the third person, they were here in their numbers. So we thank you very much for attending upon us. Honorable nominee, you will surely hear from us. You are accordingly discharged. Thank you very much.
Honorable Chair.